Okay, Blake, can you hear me? Oh, I'm muted. Okay, Blake, can you hear me?
Yes, I can. Can you hear me?
Yep. So we're
Good deal.
ready to get started. Sorry for the delay, everybody.
All right, thank you, Brandy. And we're going to kick off with the Board of Adjustment, right?
Yes.
Okay, I'd like to call to order the Thursday, July 9th, 2020 Watertown Board of Adjustment meeting. Can I get a roll call?
Kays,
Here.
Hanson,
Here.
Dolly,
Here.
Aletsky,
Present.
Brink,
Here.
Ford,
Here.
and so then also just to note here, Mark Stein is now resigned from the Plan Commission and Board of Adjustment, and his replacement will be William Spire, and he might be joining us still. So we'll see, but otherwise, so Spire, Dargis Johnson, and Culhane are absent. We do have a quorum.
Thank you, Brandy. First item on the agenda today is the approval of the minutes.
I'll make a motion.
I'll second that.
Oh. Motion and a second. Any discussion on those minutes? All right, none. We'll take a roll call vote.
Kays,
Here. Yeah. Yes. So sorry.
Hanson,
Yes.
Dolly,
Yes.
Aletsky,
Yes.
Brink,
Yes.
Ford.
Yes.
Motion is passed. Move on to item 4 on the agenda is appeal number 20345.
All right, thank you, Blake. So this is the owner applicant, DPC Properties LLC, appeals the terms of the zoning ordinance seeking variance relief to allow for the construction of a non-conforming storage building in the I-1 Light Industrial District at 429 14th Street Southwest. And I will share my screen here so you guys can see there. All right, so, and if I pull up GIS, this is the property here. If you guys recall, we gave a variance for the storage unit that was proposed in the northeast corner of the property. Now we're looking at the building on the southwest side of the property, and I'll pull that back up. So this was the building that we gave prior variance for, and then now this is what we're looking at today. What they're asking for is a 10-foot side yard setback when the typical side yard setback in the I-1 district is 20 feet. So that is what we're looking at today.
And Brandy, as far as that property line goes there, it looks like it jogs in on this site map here on the GIS that you just showed. I didn't see that same jog. Is there a discrepancy?
Nope. So there actually is. You'll see that some of the former Terex property, it does jog. So, and then we did vacate this right-of-way of Oakwood Road previously too at Plan Commission, and City Council approved. And so this property line actually comes down now. So that's
Okay.
where it looks like it doesn't on the GIS. But so what they've shown in their survey is accurate.
Thank you, Brandy. I'll go ahead and open the public hearing on this if there's anybody to speak on behalf or against.
Brandy, so we're looking at, I'm going to say the third building or the farthest to the southwest. Where will that be accessed from?
So they'll have an access onto 4th, and then also 2 accesses onto Oakwood Road. And I don't know if that is not shown here. I can pull something up.
While Brandy's looking that up, just for clarity to that question, the accesses have not been approved as of yet, but once a full modified site plan has been submitted, we will review and approve those at that point in time. So what Brandy is showing is a schematic or proposal from the applicant at this point in time, but not a hard, fast approval by any means yet at this point.
Yeah, good catch there, Heath. So where they're showing, these are the proposed accesses.
Brandy, I have a question for you. When I look at the drawing of the building or the layout, they've got a 10-foot side yard easement. That's where they're requesting their variance. But then on the back side, that side yard easement is, or that distance is 68.5 feet. Why isn't the applicant able to just shift their building back and fit? I mean, I see it might cut off into some of the easement, but I mean, it would get a lot more, be able to get a lot more of it in, I guess is how it looks to me.
Out of the setback?
Yeah.
Yeah. And I'm not sure if the applicant has called in or if they're here.
It looks like we might have the applicant on. If you are, if you could state your name for the record and then answer the question from the councilman.
This is Dave Redlin with DPC Properties. Can you hear me?
Yep.
Yeah, we can hear you.
Okay. So one of the reasons why we're asking for this is, yes, it does state 68 feet. However, if you see, her screen just went away.
Oh, sorry. Oh, I can't hear me.
If you see toward the left there, it's 36 foot to the big mainline power poles. Yep, right there. So it's difficult to back trailers, campers, things such of that nature into these garage stalls with that power pole being in the way.
I have a question. This is Diana Ford. Can you hear me, Blake?
Yeah, we can hear you. Go ahead,
Okay.
Diana.
I see that when we approved the when we approved that building up in the corner on the May 7th meeting, this building on that plan was 30 by 200 instead of 35 by 204. I'm curious to know why it went from 30 to 35. That extra 5 feet could make a big difference in that asking for 10 feet or 15 feet.
Dave, do you have a response for that?
I guess to better suit the needs of different customers for what they're storing, we decided to make it deeper, to accommodate things such as campers and larger boats and things of that nature.
And I apologize, that was Matt Redland speaking, right?
No, Matt is out. That was my business partner, also DPC Properties, Darren Waldner.
Okay, you guys all sound alike.
Matt's not here today.
Okay.
So
And so it looks like the reason with the proximity to the other power poles, also to the north there, is that the access for the other buildings is from the south side exclusively.
We're,
It's just, we're just trying to maximize it around those utilities. I mean, it's a dot on the map with those 2 power poles, but you start bringing trailers and things in there, it really cuts down on what you're able to do. So by shifting it back like that, we're able to better utilize that space there. And that's, driving it is what the people that want to rent them are asking. And
this is actually a 3-phase project, so the only one we're actually focused on today, this year, is that building in question today. The other ones might be a couple years down the road.
Just keep in mind though, for the variances, that you do have to utilize them within 1 year.
Okay?
And so, Brandy, if they are granted this variance for the 10 foot instead of the 20 foot, that means they won't meet the 15-foot boulevard requirement at that spot. Is that correct?
Well, actually, this is considered a side, and so that is only when it's adjacent to a public right-of-way, which is typically the front.
All right, thank you.
Yep.
Any additional questions for the applicants?
just one more. So is there only going to be garage doors on the side by the light pole, or will there be doors on both sides of the building?
It'll only be on the north side facing the power poles. For that particular building.
I'll ask if we have any other comments from the public while we have the public hearing open. Hearing none, I'll close the public hearing. I'll need a motion from the board for consideration and discussion.
Mr. Chair,
Yes, sir.
this is Kays. I make a motion to approve the variance as requested with the findings, my findings to be included that the oddness of the lot and the location of the utilities make it difficult to meet the requirements of the ordinance.
A motion by Mr. Case,
I'll second that.
second by Bonnie. Any additional discussion on this one?
Yeah, I'll kind of just kind of reiterate what Todd said. I think with the uniqueness of this lot and how it's adjacent to a parking lot, I feel that a variance here could be acceptable.
All right, we'll take a roll call vote, please.
Kays,
Aye.
Hanson,
Yes.
Dolly,
Yes.
Oletzky,
Yes.
Brink,
Yes.
Ford.
Yes.
Motion passes. We'll move on to item 5 on the agenda, appeal number 2229.
Yes.
Mr. Korth?
Thank you, Blake. So the owner applicant, Robert Korth, appeals the terms of the zoning ordinance seeking variance relief to allow for the enlargement of an existing non-conforming structure located in the I-1 Light Industrial District at 320 Skyline Drive. So let me get to the exhibit here. Okay, so, and let me show you on GIS so you have a little better idea of where we're at. All right, so it is this triangular property located just north of 3rd Ave. Over here is Lions Park, and then this is Muth Electric. So Robert Korth purchased this property, I believe, last year. And what he's wanting to do is add on to the existing structure, which is non-conforming because it's within the setback, which is the 20-foot, again, 20-foot side yard setback in the I-1 district. So initially, when this structure was permitted in 2014, I believe, it was supposed to be conforming. And let me bring that back up. So as it was permitted, it would have been conforming to the setbacks. This property also has a lot of easements within it. And this is oriented the opposite way. Oh, bear with me here. Okay, so you'll see there it was supposed to be placed as a conforming structure. How it was actually installed, it now is within the setback. So there, this is the existing structure. And it's also encroaching actually 0.7 feet into the adjacent landowner's property, which is the Burlington Northern Santa Fe Railroad right-of-way. So you'll see there, and you can, on GIS there, it's encroaching over that line. What he's proposing would actually be conforming. He's not encroaching in the setback, but it's enlarging a non-conforming structure. It's not typical that a building would be built over lot lines. Definitely not permitted for that to be allowed. We did tell the applicant to reach out to the adjacent property owner, but was not able to be in contact with them. So that's where this one is at. He's asking for a variance to enlarge a non-conforming structure.
Back in 14, when he got the first building permit, it was for a 28 by 28, and he built a 26 by 30. And that's why it's into Burlington Northern's land?
Well, it actually was, so you'll see, it was actually supposed to be outside the 20-foot setback altogether. So I'll go back down to the original permit.
Yeah, that's what I was looking at, too.
So they would have been, so it was actually 32.4 feet off of the property line, so they would have been outside of that setback. So it really got slid over to the west. Not sure
Wow.
how that happened, but.
Brandy, this is Todd. Who was the original applicant of the original structure?
Mr. Longworth, I believe. Let me find that. David Longworth. So now it's a new property owner wanting to enlarge the nonconformity.
It looks like this is the time for the public hearing, so I'll go ahead and open the public hearing if anybody's here to speak on behalf or against. Is Mr. Korth in attendance today?
It does not appear so unless
Do you think
he's
that
online.
Sorry, do you think that when Mr. Korth purchased the property that he knew that the garage was not where it was permitted to be built?
No, I don't believe that he knew that.
Okay.
We'll check one more time. It does appear that there's a few people on the phone. Is Mr. Korth or anybody else here to speak in the public? Do we have any similar situations, Brandy, to your knowledge, where variance has been granted on something that is encroaching on another property?
No, that's not typical. Unless they would be signing off on the application.
And the guidance to the applicant was that the applicant should seek out communication with BNSF in regards to that.
Yes.
City staff hasn't made an attempt to reach out to them.
No, we put that on the applicant, and when the applicant was not able to be in touch, we still are allowing him to come to the board. That was his wish. And Matt, if you want to speak on that, speak to that at all.
I think I'm, are you sharing the screen or something?
Yeah, do you, I can stop sharing. Did you
All
want
right,
me
anyway,
to?
Yeah, so we did advise him to, first reach out to the neighboring property owner. I think he got 2 surveys to confirm that the building is indeed over the property line. Obviously he's dealing with a property owner that's a pretty large entity with, all sorts of decision makers or lack thereof. And so it's not like he just can go over and knock on his neighbor's door and ask permission. So obviously I think that's an issue there for him. He's not able to really reach anybody. But at the end of the day, he wasn't able to procure any sort of agreement or a co-application with the railroad. It raised a little bit of an interesting issue with, internally with staff about, when can people, can we say somebody doesn't have the right to come ask the board a question? And so I determined that there's nothing prohibiting him from asking the question, even though we believe that there should have been a co-applicant on this case. But we believe that he still could come forward and ask the question for the variance, and so that's what's in front of you today. The board could consider some sort of a condition where he would have to obtain a permit or an agreement or a easement or something like that from the railroad. That could be an option for the board to consider.
Could the railroad department later on decide, hey, I don't want that corner on my property and I want that corner removed? Can they do that?
Yes, technically he's encroaching on private property. It's not, I shouldn't say he is, but a building that he now owns is encroaching on
Right of way.
on right of way, on railroad right of way. And so if they so choose, they could try to have him remove the corner that's encroaching.
And from a standpoint of, alleviating that encroachment, all you would technically have to do is to remove anything that does cross the property boundary.
I just,
Yeah, and I had the conversation, we explored that with him, and it sounds like it's, I don't claim to be a contractor, so it sounds like it's a lot harder for whatever reason. It's a lot more difficult than it may seem to just shave off 7 inches off that corner with this particular building.
Mr. Chair,
Yes, sir.
I have a question regarding the field inspection report card that's included in the packet. It appears that David Longworth, so are we saying that the city signed off on the field inspection of the property after it was constructed?
Randy, do you know?
it appears that they did.
So it says the status set to site plan for setbacks. I'm not sure what that means.
Mr.
But
Chairman, if I may.
But if the footings were in place and tied to rebar and the city signed off on the field inspection, does that mean that they blessed the building there, even though it was not done in accordance with the original building permit?
Mr. Chairman.
We would have no right to bless the building bless trespassing, I guess, for lack of a better answer. But it appears we could have signed off under the assumption that they were the original proposed footprint.
Heath, do you want to?
Yeah, if I could, Mr. Chairman.
Yes, sir.
So the inspection reports that we perform, as far as the city's building inspectors are concerned, one of the things we do not do is require a foundation location certificate in the city of Watertown, an FLC, it's otherwise known as. And what that FLC does is it confirms that the foundation has been excavated and installed in the exact location as shown on the proposed plan. So short of having that document from the owner, and short of us doing an actual site survey of our own, we do not do a solid confirmation of any kind that confirms that the location of the foundation is accurate based on the building permit. That responsibility falls on the owner or their builder to ensure that it's built within the guides of the permit that was issued.
And if I could add to, just for the public record, that Bill Spire has joined us, and so he is the replacement for Mark Stein. Just wanted to add that so he can participate. Welcome.
Thank you, Brandy. Welcome, Bill.
When I look at this application, I really have two concerns with it. One, their original permit didn't have a variance, and then they built something that had a variance. So if we allow an addition, we're kind of saying that we were okay with that variance. And second, they built into someone else's property, and I don't feel that we should encourage the expansion of buildings in other people's properties. I have a hard time with that.
I think the unfortunate thing about this is how it was permitted. It was conforming. There were some sort of inspections, but like Heath had mentioned, we don't actually survey the site. And then actually what he's proposing would not be non-conforming. It is within the setbacks. It would be almost up to Burlington Northern BNSF to ask that area that's encroaching in their property be removed. It is also within our 20-foot setback. But what the building that he's wanting to expand, though, would be within it would be conforming to the setbacks. But it is enlarging the nonconformity, so.
Enlarging a nonconformity on a building that is encroaching onto somebody else's lot.
Yeah, I agree with you, Jeff. It does seem like it has some implicit acceptance of the original variance, whether intentional or not.
Brandy, do we know the type of construction of that garage? Is it a pole building or a conventional stick built?
Let's look here. It was. It looks like it was just conventionally built. It's not a pole building. Oh, okay. I'm sorry. I thought it said siding on sheath. It is a steel building, but it's not. Usually, if it's a pole building, we'd put column. Let's look at the wall detail.
And just to note, Mr. Chairman, I believe Mr. Korth maybe has called in now if any of the commissioners would like to direct any questions towards him. Is that correct, Robert? Are you online now? I see his number. Pete, what is the unmute for the phone? *6 to unmute. Robert, if you can hear us, is *6 to unmute. 8309.
I was. Go ahead.
Yep, I think we got you.
There we go. Okay, I was talking all this time trying to get through, and I get it now. I apologize for the delay for me, but before, when this building was built, talking to the previous owner, I do not believe that he actually anticipated encroaching onto the railroad's property. Many times he's told me that there is only a 20-foot span between the railroad and the property line. So he went over far enough, is what he said. But apparently it is on the railroad's property because there's a 50-foot piece of land that the railroad owns, and the building is sitting over probably 2 inches on it. But the intent was not there to begin with when it was built. At least I don't think it was. And the lean-to that I am proposing, it would be, we have the Lions Park right here. People want to sit out on those picnic tables, and there's a nice lake here. I don't want to have clutter over here and a bunch of junk sitting around outside underneath the tree or something, for all people to look at. I just want to keep the city clean. Put my stuff in the storage, have a small lean-to on here. I guess that's what I'm asking, even if it was just something with a roof over it and it'll never be heated, at least not to my knowledge. I don't know. I understand the way it is. It's encroaching on the railroad's property, and it's hard to add something onto a bad deal.
And Mr. Korth, can you refresh us on your attempts to contact BNSF Railroad in regards to the encroachment?
I was doing multiple attempts first of all, I stopped him right here in the tracks, the white truck. Then I called Aberdeen. Then I called a bunch of people in Fort Worth. I seemed to be getting nowheres. Today, there was more people here from the railroad, and I talked to them, and they go, there's 40,000 people that are employed there. To get the right one with the authority to sign off is probably next to impossible. I'm sure I could do it, but it would take a lot of time. And for me to go through all those steps and time, I would say, no, I will figure out something else. It just seemed like it was an uphill battle that I couldn't perform.
And Brandy, as far as the encroachment goes, the addition is actually on the opposite side, so it's not further encroaching within the property of BNSF Railroad?
Yep, that's correct.
So it doesn't change the nature of the encroachment in any way?
Nope. It just enlarges the existing structure.
Mr. Korth, I've brought this up a number of times in regards to Lions Park, but we're missing sidewalk on the south side there of your property between Lions Park and the adjacent residential area in the east there. Your property and Muth Electric and one other property. Would you put sidewalk in and fulfill the boulevard requirements of your property in relation to this application?
Down on 3rd Avenue?
Yes, on 3rd Avenue.
Well, the property that I own comes to a point there. There's, I don't know what responsibility I would have there because it's, Skyline Drive comes through there, and then Longworth has got the triangular piece right exactly next to Muth. I don't own any of that.
Oh,
Okay, so Mr. Longworth retained the triangular piece adjacent to Muth. You only bought the other wedge.
Yes, that wedge that comes up to a point there. And I was under the impression that I was buying that when I bought it. That's probably why I told you guys that, but I didn't get it.
Yeah, and I guess
I had
I
to
was
go
under
to
the other impression as well, considering the original application had a structure shown in that location.
Exactly. Yes, but I do not. Mr. Longworth brought that to my attention immediately when I was showing him, telling him what I wanted to do, and he said, "You didn't get that." So I was unaware of it at the time when I even purchased it. And then Skyline goes through there. What is that? 30 feet wide, I think, also.
yep. About 32, 33.
Mr. Chair?
Mm-hmm.
Yes, Mr. Case?
Yeah, Mr. Korth, you said it's about a 2 or 3 inches into the railroad property?
Yes. Yes.
And is there something structurally significant that you couldn't shave 2 to 3 inches off the building?
Well, that would be the corner post on the outside.
Yeah,
So
but
it'd be
you could take a corner of it and it could be done. As I'm just asking
Everything could be done. Yeah.
If railroad
Yeah.
said that you got to remove it, would you be looking at moving the building further to the east, or would you just try to shave the corner off?
I would shave the corner off if the railroad said, "Get off my property." And I would take the lean-to down if the railroad would complain to the city, "Why are you allowing this non-conforming structure?" I would do that in writing to whoever, as long as I own it, and to the next owner from here on down.
You would hold the city harmless in the event there was any issues associated with the granting of the ability to expand that non-conforming building.
Absolutely. And not only that, I would even have it in the contract to where from here on, it'd be like an easement for the city into continually owners after I'm gone.
Thank you.
Mr.
Any
Korth?
additional questions?
Yes,
Yes, sir.
I have a question for Mr. Korth. So in the letter that he had addressed to the Board of Adjustment, he's asking, it addresses 2 10 by 24 mobile sheds along with this addition, and is that still in your plan, or what would be your potential use for those mobile buildings?
They're withdrawn.
Well, I'm not asking anymore because I forgot all about them because I do not own that triangular shaped piece of property that Mr. Longworth owns. But yes, I'd like to have that under consideration, the other one to put out here.
We got a note on the application here that the 2 sheds were withdrawn.
Well, then let's withdraw them.
So I believe, yeah, that the application before us is just for the lean-to, correct?
Yes, the application before you is just for the lean-to. I would probably move forward with asking for an enclosed, a movable structure, one of those. If this doesn't, if you don't grant this, you don't, then I would go that way. Just to, I need something here for items.
Those sheds,
That
at
would be
least,
my-
Robert, you could put them in the actual buildable area of the lot. Unless there was another reason why. If there was a reason why they couldn't meet that, you could also just get a permit for that shed that would be conforming. And then maybe you wouldn't have to come back to the Board of Adjustment.
I understand that, but the way this property is and the driveway, and there's one shed here, it would look cluttered, and it would halfway be in the way. I would rather have it away from the property here a ways. That's the only reason that I would ask for it that way. But yes, I believe that I could get a permit or whatever to bring in a shed here. If worse comes to worse, then we'll go that way.
Right, but so for today, just to be
But
clear, this is just an application for the addition to the existing garage, the non-conforming
That is,
structure.
yes, we'll just, yep. That's
Okay.
how we want to do it.
Thank you, Mr. Korth. Any other comments in the public hearing before I close it? Hearing none, I'll close the public hearing. I'll look for a motion from the board.
Mr. Chair,
Yes, Mr. Case?
for purposes of discussion, I make a motion to approve the variance to expand a non-conforming structure. I'll leave it at that, and then we might have some justification one way or the other after discussion.
A motion to approve as presented.
I'll second.
Have a second.
I would
I
just,
want-
For discussion.
I would just
I
like
want-
to reiterate, I don't think we should perpetuate a building that's over the lot line, and hold the neighbor happening to be the one to say, I want this moved. I mean, I struggle with that.
I agree with you, Jeff.
This is Todd. I also agree that I don't feel it's appropriate to expand something onto the property that's owned by the railroad. If the structure was completely on its own property and due to the uniqueness of the lot and the gentleman purchasing the property, maybe not understanding, the rules and regulations, you can maybe see some of that. The only way that I would support the motion as made would be as if there was some sort of amendment stating that we would allow the expansion, but the building owner would have to shave off the 6 inches or of the corner of the building, or would have to present notice from the railroad that they were fine with it.
Would you require both, shaving the building and the railroad saying it's fine with it?
Either or.
Either or, okay. So even if I would write up a contract, a legal binding contract stating that I am totally responsible for the lean-to, not holding the city or any heir from whoever owns the property, that wouldn't be good enough for you? You still want the building off?
Let me,
Or approve.
Mr. Chair, let's parse this. I'd make an amendment to my original motion to allow it subject to the applicant signing a deed restriction upon the property where he would hold the city harmless on any actions from the railroad, and that if he would agree to shaving the building if the railroad so intended. We'll start-
So a motion for
Motion on that in a second, then we're back to the original motion.
motion. Do I have a second? Anybody from the board second that motion? Ask once more. There's no second on the motion for the amendment.
Mhm.
So on the table, we have before us a motion to approve as presented. Any additional discussion or secondary motions?
Hmm.
If there's no additional discussions or amendments, then we will go ahead and proceed with the roll call vote.
Kays,
No.
Spire, Hanson,
No.
Dolly,
No.
Oletsky,
No.
Brink,
No.
Ford.
No,
Motion fails.
Okay, I guess I'll have to proceed from there. Probably
Thank
get
you,
a
Mr.
carpenter in here to see what
Thank you,
it would
Mr.
take to
Korth.
remove it.
Yeah,
Yep.
if you can come back with a different plan, we can certainly hear it again if there's a substantial change to the plan.
Well, it's not out of the question to get a carpenter in here and find out, what's it gonna take here, what's it gonna cost, and then we'll go from there. That
good.
sounds the most reasonable than for me to hunt the railroad down,
Thank you, Mr. Korth.
so. Yep,
Sounds
thank
good.
you all.
Thank you.
Bye.
Moving on to item 6 on the agenda is open public comments. If there's anybody here to speak on an item that wasn't covered today on the agenda for the Board of Adjustment. Anybody in the room there or on the Teams meeting? Hearing none, we'll move on to item 7 on the agenda. Old business.
Yes, thank you, Blake.
Sure.
So this is the reconsideration of conditions for conditional use application 2293, which this is from the June 18th Board of Adjustment meeting where we looked at storage units on a lot in Kempesca Dunes, or a parcel at this point. It would be replatted before a building permit would be issued in Kempesca Dunes. Let me get there.
And the question before us here in old business as we discuss this is simply whether or not the board would like to reconsider this at a future meeting. There is no public hearing noted on the agenda for this item.
Mr. Chair,
Yes, Mr. Case.
could you, may I ask the city attorney a question?
Yes.
Mr. Matt, would you kind of just explain of how we got to this point on the reconsideration under Roberts?
Yes, so, can you hear me?
Yes, we got you.
All right. Essentially, under normal circumstances, if somebody brings a request in front of the board and they don't like the result, they can appeal the result to the circuit court. That's the normal course of proceedings. In this case, the applicant has asked us to ask the board to reconsider the requirement, the siding requirement. And originally it was thought that the remedy for the applicant would be to basically come before the board in the public comment section, ask the board if they would consider making basically asking the staff to put it on the next council or next Board of Adjustment meeting to consider the applicant's request. In this case, we decided that it warranted some special consideration because the applicant was having difficulty calling into the last meeting. And so because of that, we moved forward with noticing the public hearing for this meeting and putting this on the agenda so the applicant can be here to have the discussion with the board.
Thank you for the clarity on that, Matt. So this was in fact public noticed then.
Yes.
My understanding it was. Brandy can confirm that.
Yep, it was. And then we also sent out the same adjacent landowner letters to notify the neighborhood.
Okay.
So basically what we're looking at, and I passed out the minutes for that we approved. And I can read the discussion that took place. So there was discussion about the need for screening and what kind of lighting would be used. There was also discussion about the type of siding that will be used. Motion was made by Kays, seconded by Brink. Motion to approve with the condition that screening be required at the west and north property boundaries at Block 3 at the discretion of the applicant if it is fencing or shrubbery. Aletsky made a motion to amend the original motion that compatible siding to a house, residential siding, be used as well as the screening discussed in the original motion. And then voting in favor of that, Ford, Hanson, Dargits Johnson, Aletsky, and Brink. And voting against was Culhane and Kays. Dolly and Stein were absent. So then that the motion to include the residential siding passed. So then it moved on, so they had to include the screening, and they had, let's see, was the lighting a part of it? But it's also, that was just an ordinance, the shoebox lighting, that there wasn't any light pollution to neighboring residents. And then, but also that it include residential siding. So what the applicant is here today in person, so we won't have any technical difficulties, then he is asking that we reevaluate that, that portion of the motion to allow for metal siding, which is typical for storage units.
But typically in like the garage, that new zoning that we have with garages, they have to have the residential type siding. And that's why the motion was made, because it's surrounded by residential homes, not other commercial homes. And I wanted to, as people are driving into the neighborhood down Golf Course Road and stuff, and I wanted it to be more conducive to run along with the whole neighborhood, because these are all very nice homes, and we want to maintain, you know, the neighbor, just to conform with the neighborhood.
So one of the things that we had originally talked about when we looked at the overall preliminary plan here was about the need for buffering in the zoning. So we do have R3 that completely surrounds that property, followed by some R2 before it shifts into the R1 zoning. And that was a discussion item at the time that we talked about that zoning, you know, specifically to have some buffer zoning in between there with the denser residential zone. I think the other point that maybe is relevant to the conversation here, and I apologize I couldn't attend the last meeting. I did watch it after the fact, and Brandy, that's a good summary. Is the difference between, you know, this requirement and what we put in when we talked commercial lake district. So Brandy, it might even help if you could pull up the commercial lake district, because we talk a lot about aesthetics there and protection of residential neighborhoods, because it's critical to the lake environment. But in that case, within that ordinance where we're protecting the R1 that's adjacent to it, we don't get into those strict requirements except on the face that is facing and immediately adjacent to R1 property.
Right. And we also we looked at the CL district and if that would be an appropriate corner for that to be, but it is not within the boundary that we approved when we approved the CL district.
Right. But from a restrictionary standpoint, you know, we put a lot of those restrictions into the CL specifically to accommodate that scenario. And it seems what we ended up doing, perhaps inadvertently, perhaps not, is imposing a more strict requirement on this property than we would have even within the CL. And we had extensive discussion upon the CL and what these aesthetic and construction material requirements would need to be.
Correct. Yep.
Mr. Chair, have you opened the public hearing yet?
I'll do so now. If there's anybody here to speak on behalf or against.
Yeah, you can come up. Give a little.
Yep. Okay, I'm Paul Carlson. I do own the property in question that I'm working with Aaron Bowling to sell to him for the construction of storage facilities for boats, campers, that type of thing. I've got some information here I'd like to read off and to try and answer some of the questions and also question some of the answers. As I'm stating here, I am the owner of the property, Campeche Cadoon Second Subdivision. out there by the Derby Downs area, rodeo grounds. And I'm here to discuss proposed storage facility for Aaron, who is intending to purchase the southeast corner of this subdivision. The storage project would be 4 units in total, with dark brown lower section and light brown or possibly dark green upper section on the vertical walls. Would be steel siding is the proposal, with the roof matching the dark brown of the lower section. These units are intended for cold storage only for larger boats and campers. Side walls would be 14 feet high with 12 by 12 roll-up doors. The only lighting would be in the center courtyard area in order to provide lighting for visibility at night. North side of the north buildings and west side of the west buildings would not have any lighting. Each unit will have the opportunity for power outlets and lighting inside only. Tenants would be allowed to store only inside these units. And with your screening identification there, what would happen is we would plant trees along the north side of the north buildings and along the west side of the west buildings to provide that screening for future housing development in that area. The length of each of the north buildings would be approximately 162 feet. Trying to install siding such as on such a long run would be very difficult to try even try to keep that straight, and it would be very noticeable in our minds. And the wall construction would be much more expensive, and the siding costs would be much more expensive. By forcing Aaron to use this type of siding, construction costs would be higher than planned and basically would stop the deal. In addition, the city would lose tax dollars from the sale, construction of the building, and property taxes and all future rentals. I've walked around my neighborhood to the north of this area and with a petition, and all but one person in my neighborhood signed the petition saying they are fine with the steel siding and they do not feel it would impact the value of their homes. And in fact, 3 or 4 of those neighbors are very interested in renting once this unit would be complete. I do not intend on doing any developing of the remaining area. I do not have the financial ability to take on such a project. I've been working on trying to sell off this small corner since last August, and I feel I've been jumping through hoops to get for this to proceed. I spent $20,000 just on the engineering of a development I do not intend to create. I think it's ridiculous that something like this should take so long, number one, and that I had to update a housing development plan that is only good for 6 years, that again I have no plan on developing myself. I also feel that upon the final step of finishing this in order to sell, by making this project use horizontal siding at the last minute is unjust. This should have been made aware to us in the beginning. I'd like to know where in the ordinances it states such requirements, and all other storage facilities in this town use steel siding. Almost none of them have any screening, yet they all adjoin residential homes. My area in question is not by the lake, and there are no homes within 200 feet of this proposed structure. And I'm asking you to please reconsider this and allow us to proceed with this project with the use of the steel siding, just like almost all other storage facilities in Watertown. And I guess that's what I've got, and I am open to questions or comments. And again, I have Aaron Bowling here that you can ask questions also and go from there.
But you talked to all of the neighbors down that, what is that, 11th Street, and then
12th.
along
12th Avenue.
Sorry.
Yep.
And then along the corner and stuff, you talked to all of them and they were all fine with that?
I talked to the people on 12th Avenue there, and anybody adjoining that acreage, all those people agreed that they would not have a problem. Also, some of the people adjoining the golf course in that block area agreed that, you know, they don't have a problem with it. I had one person who was against it, and I guess again, just like everything, democracy, one person should not have that much power to try and shut things down like this. And, you know, I guess that's what I have to say there, but I've got the petition here, if anybody wants to look at it, with the names, their phone numbers, their addresses, signatures, and all of that. So, and again, you know, where this building location would be, it adjoins an open field that's going to be an open field for hay for some time. And, you know, it's, I don't feel that it's going to be a detriment to that area where it's going to affect the cost. And then as that development gets put in someday, then
It makes me feel a lot more comfortable that the homeowners are fine with that live along there. That really makes me feel a lot more comfortable with that. I'm
Yeah,
glad that you went and talked to them and told us that.
I talked,
Thanks.
like I say, I talked to as many as I could. A couple of them weren't home. But, you know, and I wanted to go around even over, I call it the Meester edition. But I wasn't able to get over there in time. But to me, the most important are the immediate neighbors. And, you know, we're not a close group out there, but we know each other, and I feel that we are open with each other. And I explained to them, you know, if you're not in favor, I'm not offended if you don't sign this, but if you're okay with it and you don't think it's going to be a big impact, I would appreciate the support. And so they, you know, ambitiously did it. And like I say, a couple of them said, you know, yeah, I want it up because I got to get some junk out of my garage. And so another one's got some, I mean, I hate to take business away from another place, but they've got storage in town, and they state that it would be much nicer to have it closer and more accessible. And like I said, and Aaron can back me up on this, the property, maintenance-wise, is designed where nothing is supposed to be left outside. You're renting that stall and what's inside that stall, and that's where you store any of your items. Anything left outside will be asked to be removed. So that's kind of where that's at.
Thanks. I appreciate that.
Okay, thank you very much.
Hey, Mr. Carlson, one additional question yet, and I think you already clarified it, but just in regards to the tree screening,
Yes.
no additional qualms with planting those trees?
No, you know, the project, and I guess I don't want to speak out of turn for Aaron, you know, all 4 buildings are not going up at once. So what we'd be doing, or what he'd be doing, is starting construction on one, and once that's up and rented, then he'd start construction on another one. And as he has the time to do it in that area, he is going to proceed to be planting trees along those north and west areas. And, you know, right away they might not, you know, they're not going to be 12-foot tall trees, but they will have that chance to grow over time, and someday down the road, when the development is there, those trees will be mature enough to help screen the facility and make it aesthetically pleasing for the neighboring people.
Thank you, Mr. Carlson. Public hearing is open if there's anybody else to speak on behalf or against.
Hi.
Anybody else to speak?
My name's Brian Brandwright. I feel like Mr. Carlson really has jumped through quite a few hoops here. I I like the looks of his building. It's attractive. As a builder, you kind of need to watch how much money you put in these projects, or there'll never be any return on it. This is something that is needed in that area. I feel like we could make this happen, and it would be a good-looking structure. Wood siding naturally deteriorates, needs painted. 7 years down the road, if he doesn't keep it painted, it'll look bad. This steel would certainly stand up for years to come. I think he's got a really legitimate little project here. I'd like to see it passed. Thank you.
Thank you. Anybody else in the public? If there's no other comment, we'll close the public hearing.
Mr. Chair,
Yes, sir.
this is Kays. I'd like to make a motion to approve the, I'm not exactly sure the proper motion for this, Mr. Parliamentarian, but it would be to approve the conditional use permit absent the requirement of steel siding that was placed upon the application at the previous meeting.
Absent the requirement for residential siding?
Yes. Sorry.
Or do you think it might be better if I just rescinded my motion to the motion?
Well,
I think we
Yeah.
take a new,
to me, it'd be a substitute motion, but I'll leave that to the parliamentarian.
I think Todd's motion here is on the table and valid. Would need to be seconded. I think that's an appropriate road to take if that's the route that the board wants to go.
I'll second that motion.
okay. We have a motion by Kays, a second by Oletsky. Any additional discussion on this before we take a vote?
Yes.
The basis for my motion was that I didn't vote in favor of the motion for the residential siding last time. I was against that. I think with the further evidence provided by the applicant and that no showing of anybody in the neighborhood showing opposition to the proposal, that we move forward as the applicant has so desires.
Thank you, Mr. Kays. Ms. Ford?
I certainly understand where this gentleman is coming from, and my opposition to this is not related to the project at all. It's to this procedure and process, because an appeal from the Board of Adjustment, according to our ordinances, goes to the court system in the manner provided by the laws of the state of South Dakota. And I'm having a little bit of difficulty understanding how we're bypassing that with this reconsideration of conditions. I don't see that as an option for us as allowed by our ordinance for the state of South Dakota. I'm still uncertain about this whole process.
Look, Matt, for your input on that.
Yeah, I guess I'll just try to clarify that a little bit. You are correct. The normal course of business, if an appeal from a final decision of the Board of Adjustment goes to the circuit court. However, we do also operate under Robert's Rules of Order by ordinance, and Robert's Rules of Order does allow for things like reconsideration and amendments to prior actions and setting aside of prior actions. And so that, coupled with the fact that in this case, the applicant was not able, because of technological reasons, was not able to participate in the discussion last time. That's why it's before the board today. And so I would remind the board that just recently we did do this in another case involving First District when a previously approved condition turned out to be unworkable or less desirable for whatever reason. We did allow a path back to the board to have that conversation. So, to be honest with you, it's perhaps something we should consider in the ordinance at some point, that because that occurred outside the 30-day window for an appeal anyway. And so I think we'd rather have people coming and having the conversation rather than just disregarding conditions. So, but anyway, I guess that's a little bit longer answer than you probably wanted, but that's where we're at today.
Actually, that's really not long enough for me. I guess I wonder if this is opening up a can of worms, and who is making the decisions. There is no process, as far as I can tell, no written process in the ordinance or anywhere except perhaps in Robert's Rules of Order that tells us who can come back and ask for reconsideration and who needs to go through the court system. I guess, as I said before, I'm not opposed to what the gentleman is presenting. I am worried about what we're doing to ourselves as a board down the road.
Diana, this is Todd, and I don't disagree with you. I think it just shows a shining light on the importance of this board adopting bylaws on how administrative procedures move forward. But absent those bylaws at this point, I think we have to defer to Roberts, and Roberts allows for this to happen. And I think from a due process perspective, this is just me standing on the outside. I think it's probably all right that Mr. Carlson has the opportunity to ask the question. And I think I don't think this should be standard operating procedures, but I think in this effort we don't have anything else but Roberts to rely on from a due process perspective.
Yeah, and Todd brings up a good point. You know, if you think of this, you know, the Board of Adjustment is a quasi-judicial board, and if you think of the applicant as a defendant in a court case, you know, court would never proceed without the defendant's opportunity to be heard or testify if they would choose. And so, you know, if you think of it in that case, in this case, the applicant was not able to be heard at the last meeting because of situations beyond everyone's control. We made this basically an exception here to allow it to be heard at this meeting. And I agree completely, it should not be standard procedure. But just as kind of that's where we're at.
Todd, from a standpoint of bylaws, what action should we take away from this conversation?
Well, I think, you know, we separate the applicant's request from the need for bylaws, but I do think it's something that's been talked about for many, many years. And, you know, we operate under Roberts, but I think we have the ability under statute to establish our own bylaws for the operation of the meeting. They need to be founded in the ordinance, but we still have the ability to have flexibility within our bylaws. And we should have a specific section on when is a reconsideration, you know, okay. And generally reconsideration should happen at the time of the meeting, in the same meeting later on at the end of the meeting. Or it shouldn't be something that we come back a month later and say, I changed my mind. But we don't have that flexibility as right now. But I do think it's something that we as a board working with the city attorney need to seriously consider putting together some bylaws for just how we operate our business meetings.
I'd agree with that.
Mr. Chair, I remember
sir.
last meeting, and I did vote in favor of the residential siding, and I know I was on the fence on that, and I did vote yes for it. My thoughts there were, this is in a residential zone. I know we have other commercial storage units that are next to residential, or I mean even adjacent to buildings or adjacent to houses, but oftentimes there's the separation of zoning. The storage units are in the commercial and the houses are residential. And I just wonder if we don't make that a condition when it's in the residential unit, residential zoning districts, you know, if we don't do it now, if we'll ever do it, or maybe we don't want to ever do it, but that's just kind of, I was trying to form some consistency is, was how I came up with my vote last meeting.
Yeah, I think it's certainly something to consider more completely from a whole community standpoint. That's a topic of conversation that we had in relation to the CL district specifically. CL being immediately adjacent to R1 in much of the intention, and an area that we want to enforce aesthetic and neighborhood appeal, probably more so than anywhere else in the community. We don't have those same kind of stipulations elsewhere outside of the Gateway Overlay District, but it's something that we could look at doing in more applications where we have these transitional type or multi-type usage within a zone. I think that's something that we should explore outside of just the CL district.
I might add too, it could be something that, so we have storage units as a conditional use in the R3 multifamily district. If it was something that if it's going to be there, do we just stipulate right in there that says with residential siding? Because then that might deter somebody from going this route if it isn't going to be feasible. Another thing is that with Golf Course Road and 33rd Street Northwest being two collectors, it is actually more appropriate as a commercial use. We wouldn't necessarily want residential there. And there will be residential. There's still lots you can see here that are zoned R3, and then there's also R2 buffering that before it would get to the existing R1 homes.
And I agree with Brandy. This is Todd again. And the other thing I think was brought up at the last meeting was that this is the first development of this proposed development. And so those individuals constructing homes along 11th and 10th and Carlson Street someday are going to know what kind of neighborhood they're moving into when they see the storage units on the corner. So this would be a different situation if the rest of the development was already built up and this becomes something that's coming in after the fact, in my opinion.
I think my frustration, and I kind of was the one that maybe brought up the initial non-steel siding. From our perspective, or from my perspective, this kind of came through relatively quickly. I understand from the developer's project, perspective, he's been working on this for a long time. When we see this, that we had annexed it in and changed zoning, we kind of anticipate that there's to be, eminent building and development of the property. And so I think we kind of look at it with a different set of eyes of what's really the long-term plan here. We have no control of when that piece of property will be ever developed.
But for the preliminary plan, we do show the phasing, which it's not shown on here. I can pull it up. And we did show that this was phase 1, and he also, you don't have to include buildings on preliminary plans, but he did show, and it was discussed that these would be storage units because he was showing the buildings at the time of the preliminary plan approval.
And they will be accessed off a golf course?
Yep.
Mr. Chair, I'd like to call the question.
Yeah, we'll proceed with a roll call vote.
Kays?
Aye.
Spear? Is it Spear? Spire? Sorry. Hanson?
Yes.
Dolly?
Yes.
Oletsky?
Yes.
Brink?
Yes.
Ford?
Yes.
Motion passes. Thank you, everybody. And then, Brandy, if you could just make a note, I would like to further that conversation at some point at a future plan commission meeting to talk about the overall treatment of storage units within residentially adjacent zoning or within residential zoning.
Okay, sounds good.
Any other old business?
None that I have.
Take a motion to adjourn.
Moved.
Have a motion
Second.
and a second. We'll take a roll call vote.
Kays?
Aye.
Spire? Aye. Hanson?
Aye.
Dolly?
Yes.
Oletsky?
Yes.
Brink?
Yes.
Ford.
Yes.
Thank you. We'll adjourn for the All right. I'd like to call to order the Thursday, July 9th, 2020 Watertown Plan Commission meeting. Get a roll call.
Kays,
Here.
Spire, Hanson,
Here.
Dolly,
Here.
Oletzky,
Present.
Brink,
Here.
Ford.
Here.
And Dargits Johnson and Culhane are absent, and I'll just reiterate for the public record that Mark Stein has resigned, and we thank him for his service, and we will miss him and his input. But Bill Spire is his replacement, so this is his first meeting here with us, and we're glad to have you.
Absolutely. Thank you, Brandy. Item 3 on the agenda is invitation for public comment participants submittal. So we will have a point at the agenda later on after our regular agenda items. If you'd like to speak to the board on something that wasn't on the agenda today, that'll be the time to do so. Item 4 on the agenda is the approval of the agenda. Need a motion?
Ford moves.
Oletzky second.
A motion and a second. Any discussion on the agenda? And none, I'll take a roll call vote.
Kays,
Yes.
Spire,
Yes.
Hanson,
Yes.
Dolly,
Yes.
Oletzky,
Yes.
Brink,
Yes.
Ford.
Yes.
Thank you. Moving on to item 5 on the agenda is the approval of the minutes from the June 18th meeting.
I'll move to approve.
I have a motion
Ford seconds.
and a second. Go ahead and take a roll call.
Kays,
Aye.
Spire,
Yes.
Hanson,
Yes.
Dolly,
Yes.
Oletzky,
Yes.
Brink,
Yes.
Ford.
Yes.
Thank you. Moving on to item 6 in the regular agenda. Bullet A is resolution 2020-28.
All right, thank you, Blake. So this is commission consideration of resolution number 2020-28, amending the zoning map of the city of Watertown for a portion of Stony Point from R1 Single Family Residential District, C2 Local Commercial District, and A1 Agricultural District to CL Commercial Lake Commercial District. And if you recall, the CL Lake Commercial District is the newest zoning district that we have created in 2019. So this is the first property looking to utilize this zoning. Something to keep in mind with the CL district is when we did create it, we looked into it extensively that it would be for infill development around Lake Kempesca, which is generally developed as R1 single family residential. So we did look at the design criteria or the design requirements of structures when adjacent to R1, like we referenced with the last application in the Board of Adjustment, to ensure that it is not negatively impacting the existing neighborhoods, as well as looked at greater setbacks so that if there were commercial uses adjacent to residential uses, that it would be more protected. And that was a big part of the creation of the CL district. So what we're looking at here today is, let me get to a map. And actually, I'll pull it up on GIS. It might make it easier to, again, have a little idea of where we're at if we're not familiar. Okay. So it is this, and I'll highlight it here. Not this entire area here that is highlighted, but this is the area that they are proposing. You'll see that there's the C2 local commercial up here in the northeast corner, R1 single family residential, and then the ag down south. And what they're looking to do is rezone that area to CL Lake Commercial. The area is approximately, what do we have? 26 acres. The thing to keep in mind also, and I believe I saw that Mike had passed out an exhibit of the buildable area for the CL district. We do have a stipulation on there that you can only 50% of the lot area has to remain pervious surface. So it actually cuts down on half of the buildable space, which I'm sure if they speak on behalf of this, that they would be able to touch on that further.
And Brandy, just to be clear, that's a stipulation in the CL district in general.
Yes.
Yeah.
Yeah, and it might help, just as a refresher, Brandy, if we could actually look at that CL district. I don't think we need to read through the entirety of it, but we did go through an extensive amount of work, this board and public hearings, to identify what a district in this type of area would look like, and landed on this approved CL district.
Right. So you'll see here, I have it pulled up on the screen. Are you guys able to see that on Teams? I think you should.
Yep, we got it here.
Okay.
Thank you.
So permitted uses that could go within this district are retail establishments, service establishments, restaurants, recreational use, which is like a public park, campground, storage shops, apartments, recreational facility, which would be like an indoor gym. And then the conditional uses would be a car wash, motels and hotels, automobile parking lot, storage units, office, building, bar, tavern, and a transit station. And then you'll see here we have the design standards, and then that's where the impervious area shall not exceed 50% of the total lot area comes into effect. You know, we also require that the side yards are 15 feet right here, the transitional yards. So properties adjacent to residential zoning districts shall maintain 15 feet of grass on the side yards to the extent of the entire length of the property boundaries. And then also the setback when they're adjacent to residential districts is 30 feet. And if it were a single family residential abutting another single family residential district, it would be 9 feet. So, and that was to try to create the separation between such uses. And then when they are also, when a wall is immediately adjacent to an R1 district, that it has to be finished with the following materials.
And I made reference to this in our previous discussion there, but you know, part of that, in the entire intention of the ordinance there, is to keep a lot of the aesthetic that we have in the natural environment of Lake Compesca and in a residential neighborhood, so that we have uses that are complementary to the type of amenity that we would expect to have at the lake. Thank you for doing the summary of the CL district, please.
Yep.
Proceed with the, let's see, where were we at on the GIS? You were showing the property. Did you also have, Brandy, the comprehensive land use plan?
Yes.
I thought I saw that in the packet information.
Yep. I'll pull that up if I get on the right screen. Okay, so this is the future land use and the future land use map, mixed land use. So you'll see here the point is what is labeled as regional, commercial, high density residential, mixed use. And then again here, as the specific land use, they do have it as mixed use and commercial residential in this map as well. So what you will notice though is that they are extending further to the south than what these maps are showing. And then the Lake Kempesca master plan also showed the area as mixed use. The thing about extending it farther to the south, it is still appropriate because of the setbacks and the buffers that we're creating. Also, if they're using this all for the zoning designation of CL, they can only use 50% of the land. So the wetlands there, if they would rezone it, they would also not give them the authority to fill in any wetlands. They would have to get appropriate permits from the Corps, the U.S. Army Corps of Engineers, and the Game Fish and Parks, as well as the city, and which would most likely be very difficult as they're jurisdictional wetlands and important to the lake water quality and habitat. So I think with that, we can open it up to questions or the public hearing.
Thank you, Brandy. I am going to open it up to public hearing now. Recognize that there may be many people that would like to speak on this today, so I would ask you to limit the time for your comments to give everybody a chance. Brandy, I do know as well that you had received some email correspondence and had been capturing some of that. I would like to share that into the public record.
Okay. So I did compile a list and then the messages as well. And so I guess there was 21, and now largely these were in support because of the message that was conveyed about if anybody was interested in or wanted to support the project that they would email. And so there was 21 for, and then 2 that actually did email against. And then as far as the messages go,
what's the best way to really capture these into the public record?
Maybe I'll pull it up on the screen so it will be viewed. It can be paused if anybody would like to read them. Does that seem?
I'd like to give everybody a chance to see what was sent in and expect it to be shown during the public hearing here.
Okay, we'll zoom it so we can read. Oh boy.
Did people put their name on them?
Yes.
When did that come out?
Just yesterday. They just have come in within the last 24 hours.
Well, you said you had 21 responses.
Yes.
Look, it just went out yesterday.
The post did yesterday.
Yeah. Randy?
Yes.
Yeah, I'm not sure if everybody knows what the post means, so one of the developers, maybe you better explain what that means.
Okay, so one of the developers on the project, Mike Lawrence, had made a Facebook post and just let people know that if they were in support of the project, that they could email me and then compile this, their comments, if they were not able to make the meeting. Now, everybody that's here, and if they are for or against, will still get an opportunity to speak.
Just for
This is
further,
this is something that in past, if somebody's not been able to attend a public hearing, they frequently do reach out to public staff and leave their comments with the expectation that the staff then brings it to the plan commission or the board of adjustment at the time of the public hearing, just to represent their concerns when they can't be there physically in person.
And Mr. Chairman, for another point of clarity, this isn't simply a compilation of pro comments for this project because that's what staff was looking to collect by any means. We would also document any concerns or negative comments to the project, just like we would any proponents to the project. And Brandy, if you could speak to that as far as any opposition you received in our office to the project, please. So that's on the record as well.
Yes, so on here, the red does represent the people that were against that did email. And then I did have, let's see, one person that was in opposition, and I don't know, he's here, so he'll speak on behalf of that. Or two of the people that I spoke to before are here, so then we will hear their input. Casey is on, I did include him on this list as well, and he is one.
I just wanted that to be known for the record that standard protocol, anytime staff receives comments, it's appropriate to document them, keep track of them, share them for the record, particularly when they're in this amount of volume of comments that we receive, pro or con, and that's the intent of the staff report.
Yeah, and it's not it's not typical that, well, the city does not reach out and, ask to necessarily receive this. It was because of the developer putting the information out there and then people reaching out. But it's not our standard to ask for, how do I want to say that? We always want to take input if you can't be here at the meeting, but it was not initiated by the city. And so too, because there are, long comments, that's why I'm scrolling down and stopping, so that if you look back on the video, you could take the time and read these. So.
Yeah, in some other cases, we have, read a letter or two directly into the record. In this case, there's a lot here, so I just recommend we leave it up on the screen here so that we can review and give everybody a chance. Because can everybody in the room see this as well?
It might be
Brandy?
It might be.
See, we can't read it.
And so, well, I just can't get it all on the screen then. But I guess if we just take the.
It's a little abnormal to get this, volume of response, and I just want to make sure that we are capturing everybody's comments for the record, as they do have a right to be heard in the public here. While we keep that up on the screen, though, I think we can open it for public comment from those that are in the room.
I'll minimize it a little bit so we can zoom in.
Hi. Mr. Chair. May I speak?
Yes. Yep.
Honda Williams. I live at Stony Point. I am opposed to this project. I remember my husband worked very, very hard on Lake Kempesca. He worked very hard to bridge the gap between the Watertown residents and the farmers. The Isaac Walton League, the Kempesca Water Project, Brad Johnson, so many people have worked and done their due diligence for the citizens of Watertown. This project, in the first year of the project, the DNR came out and they had 13 pages of infractions. On this board, only maybe one or two people have come out, talked to me, or seen my property. it doesn't seem like they implement a lot of the rules and regulations that you put before them. I don't see this project going forward to be an asset to Lake Kempesca. I think you should be more considerate of the residents who pay high taxes, who have built beautiful big homes on Lake Kempesca. When a developer comes in and they sell you the big sky, too many are not doing their due diligence by actually looking to see what has happened. That is not Stony Point. I'm sorry. We keep talking about we got to save this piece of property downtown, or we have to save this for a park, or we have to do that. Well, Stony Point, as we know it, or as the residents, and even as a family of the Williams, is not this piece of property. Thank you for listening to me. I hope you consider the Watertown Lake residents. On the 4th of July, I sat on my deck. There were so many people on Lake Kempesca that I witnessed 2 near accidents. I had people on Lake Kempesca who come to my business and tell me they quit, they brought their boats in, they brought their kids in because of all of this stuff going on Lake Kempesca. When do we start thinking about the residents of Lake Kempesca? Thank you.
Thank you, Ms. Williams.
My name is Merlin Joyce. I have a little different take on it. Oh, I think I'll sit down. The project itself, I think, probably should be divided in, at least in my view, in a couple of different fashions. The one that I'm here tonight to talk about is the wetlands that this covers. I live right across from the wetlands, and I was at this board meeting 3 years ago, I think, and at the time they were thinking of putting apartments across from us, and then we were assured that wasn't going to happen. Then there was going to be some mitigation with that, with some other thing. I don't know if that happened or not. But my only concern for being here tonight, my one concern, is that I don't see why it needs to be commercial. And if you so desire that it be commercial, we need some protection for all that wetland, that can't be torn out of there or covered up. Already there's a lot of that wetland been filled in on the east side, and we were told at another meeting that there would be no fill-in of the wetland, but I don't know if there's 30 feet, 50 feet, 70 feet, or whatever, but it's already been filled in. And of anything that I've seen bad about a project is messing with this wetland. Also, I noticed the former channel that was there was going to be used. Now we see it looks like a road going over to the island that belongs to the Hidden Valley Association. I have not seen a redoing of this plan. I only have in my mind and what I've seen before has now been, I would say, encroached on. So the plan that I have in my hand, I don't know if you have the same thing or not, but the light blue are the, oh, okay. The light blue is what, core regulated wetlands.
Jurisdictional.
Right. And if that's why would you want to make it commercial? Why not leave it the way it is? And we don't want anything built on it. Plus, when I was here early on, there was a talk about taking Pompesca Drive and putting a bridge across from Pompesca Drive over to this development. Then we were told that will never happen. It's far too expensive and would serve no purpose. I, for one, and I represent a few of the people because they couldn't come tonight, are asking you that if that is, in some of your mind, that should be commercial, that we have a covenant or a letter from the Corps or from someone saying that those wetlands will never be disturbed. They're there for a reason, and we want them to stay that way. And that's all I have to say. But we need to have that protected, and we need to have it in writing that it's protected. Thank you.
Thank you.
Mr. Chairman, if appropriate, I would like to speak. I'm online.
Yes.
You tell me when.
Go ahead. Just state your name for the record, please.
Thank you so much. My name is Christine Erickson, and I apologize for not being being able to attend in person. If you hear some loud woos in the background, I'm at a hot 10-year-old baseball game right now, so it's a little exciting. So anyways, with that, like I said, my name is Christine Erickson. I have been a proud homeowner on Lake Kempeska for 15 years. My husband and I actually chose to buy a home in Watertown prior to us buying our first home in Sioux Falls. We do reside in Sioux Falls, but against our parents' wishes, we chose to first invest in lakefront property. This was the best decision for our family. We are at 1030 South Lake Drive. Watertown is a second home for us. We absolutely adore the city. We visit the zoo, we visit the grocery store, the movie store, many restaurants, you name it. And we really take pride in thinking that Watertown is also our city. I do want to thank you all for your time and energy in looking at this. I do and have served on the Sioux Falls City Council for the last 6 years, so I know the challenge and the difficult decisions that you do have to make and that are balancing the needs of neighbors, and the whole entire city, as well as commercial development. You know, I was really excited to hear the abnormal response to the emails that were done. That's amazing when people band together and are able to share their vision and share what they would like to see. It's an absolute game changer. And, you know, with COVID and the economic impact in our community right now, a project of this magnitude does not present itself very often. I've had a chance to review some of the documents. I did myself proactively reached out to the developer, Mike. I did not know Mike prior to a 10-minute conversation today. And I said, we would love to have infill development like this in Sioux Falls. And while oftentimes I feel like I probably don't have much of a voice in Watertown because I don't live there, I don't get to vote, but in fact, I do live there. I pay property taxes. And the best taxes, I would say, are taxes that are paid by somebody else. And this development will be a lot of that too, with offering so many different amenities to get people to see what Watertown has to offer. This type of development really boasts the city of Watertown as a whole. And so as you make this difficult decision, obviously based on my brief comments, you'll see that I am in strong support of this. I know there are some concerns with previous comments with the wetlands, and there are extremely strict guidelines of what can and can't be done with wetlands. And the federal government does hold that very high, as well as the state, in ensuring that those lands are either moved to a different area or replaced. I don't want to act like I know what I'm talking about with that, but I know the guidelines are very, very strict with that. So I thank you for your time. I did send an email as well. I did have an opportunity to talk to several of our friends that maybe refer to ourselves as weekend warriors, when in fact probably we're much more than weekend warriors. So again, I hope you really do put this in consideration for the whole city of the whole city of Watertown, and really the impact that it can have for your amazing city. So thank you for your time.
Thank you, Ms. Erickson.
Hi there, I'm Brian Brandwright. I also live at Lake Kempeska. I think it's the most unutilized asset, and we're so blessed to have it in our backyard. The comment I heard earlier about how busy the lake was, the lake was busy. This whole summer, the lake has been busier than previous years. I've not heard one negative comment from anyone that lived at the lake. It's been so awesome to see people out enjoying. I don't want to see our lake be a good old boys club that those of us who are fortunate enough to live at the lake feel like we own the water. We own the property around the water, but we have a responsibility to share it as well. We've got somebody here that wants to spend an atrocious amount of money doing something on the Stony project there. At one point, 50 years ago, that was the biggest thing going. And everybody has great stories to tell about it. And now we can replace that with something bigger and better. I think it's a no-brainer. Every time I'm on a project, I want to leave it better than what it was before. I feel like our committee tonight has a bit of a responsibility to do the same thing. If we vote this down, who's going to come along tomorrow or next year and put up this kind of money? This is an opportunity of a lifetime. I hope we take advantage of it. Thank you.
Thank you, sir.
No, the other one. The one that came on the notice with the hashed lines. Thank you. Good afternoon. Casey DeBoer, 6205 Prairie Hills Avenue, immediately adjacent to some of the proposed rezoning area. I'm the little island right there, as Brandy's pointing out. I want to specifically address the rezoning of Outlot A and Lot 1 of Prairie Hills Second Edition. I think Brandy's helped me identify those correctly, as those are the properties that in the rezoning proposal that are abut my property. As you can see, these two properties surround my house on 3 sides. I do not believe it is appropriate to impose and surround an existing residential property with a commercial zone on 3 sides. Prior to purchasing my home 12 months ago, I reviewed the zoning of the properties in the area. I found all the properties to be residentially zoned, and in the case of Outlot A, to be agricultural zoned. I think everyone is aware Outlot A is predominantly the wetland. If when I had reviewed the zoning of adjacent properties and I had seen that the property I was looking at purchasing was surrounded on 3 sides by a commercial zone, I know I would have given me considerable pause to move forward with the purchase. My concern going forward is that the rezoning of Outlot A and Lot 1 have the potential to cause the next buyer to be concerned about buying a property that is commercially zoned on 3 sides. This has a strong potential to have a negative impact on the value of my property over time. The rezoning of these 2 lots is not essential for the greater development of Stony Point. The development can and likely would go forward if these 2 lots are not rezoned. I said at the last meeting, when new commercial development occurs adjacent to existing residential developments, there's often conflict of interests. This is such a case, and the impact on existing properties now and in the future should be strongly considered. I oppose the rezoning of Outlot A and Lot 1 because of the potential negative impact on the future value of my property, and because this rezoning is not essential for the further development of Stony Point. I ask the Commission to consider these impacts on surrounding properties as you make your recommendation, and urge you to exclude these 2 properties from the rezoning. In closing, on another note related to this development, I would like to thank the city staff and Mr. Drake for their efforts to re-engineer the road to address my earlier concerns. Thank you.
Thank you, sir.
I'm Lisa Johnson. I live just to the south of Mr. DeBoer, and the road will also affect us as well. I also looked at the Stony Point Facebook page today, and it says, "Your support is important as only the neighbors show up." Yes, we do not want an amusement park in our backyard. That's why we're here. This project will compromise and diminish our quality of life. When we bought this place 8 years ago, this was, again, just like Mr. DeBoer said, not zoned for commercial use. We have a peaceful, quiet subdivision with excellent neighbors and very little traffic. This road and development will increase the traffic behind our house, which is not meant as a public road. Of course, we deal with the 4th of July traffic, which we did this last week, the Vintique Route Run, which is cool, cooking on Compesta, etc. We should not have to deal with this every spring, summer, and fall, year-round, because we live here year-round. There's plenty of access to the lake as it stands. If you were out on the water this 4th of July, you found that everybody was on the lake. I didn't hear anybody that said I couldn't get on the lake. There's many public accesses to get on the lake. I believe Mr. Kay said the residential is already established. Why are we doing this? He said that in the last session. This road is directly behind our house. Headlights will come into our property every night. Please do not allow this rezoning to pass. This should remain residential. This is how it was presented to us when we bought and built our house. There are many other areas for the development of the lake. This is not one of them. This is a large issue that affects many individuals. I believe that this deserves more than one meeting for more people to comment and not just in favor of it. Thank you.
And just so everyone knows too, that this will be heard. If it's not approved or not recommended to be approved, it still can go forward to City Council. They would need a superseding vote, but there will be a first reading and a second reading. The second reading is where the public hearing will take place at City Council.
Okay, Mr. DeBoer, are you talking about the parcel 2? Is that what you're talking about, is parcel 2, right? On that,
I'm talking about what's in the purple on the screen. It looks like it's labeled parcel 2 on that diagram there.
yeah,
On the plat, it's labeled as outlot 1 or outlot A. And then the property to the east where the road dedication is
Mhm.
lot 1.
yeah, yeah, okay, thanks.
Eric Scott. I'm here just to speak generally on behalf or in support of the project. Again, as I believe I said last time, this is something the community has expressed desire for. Lake Kampesca is a water town asset and not, in my opinion, just an asset of those people that own the property around it. And not too many opportunities like this come along. It's taken a lot of diligence, a lot of vision on the behalf of a couple developers. And they've been very patient, worked hard. My understanding to address DENR concerns and everything else. So, and there's just not very many places on the lake that are left to do something like this. So, I think it's a great project. I think it'd be great for our entire community. While it might not be great for every single resident out there, and it might inconvenience some, it's in general good for the community, and that's why I support it. So. Thanks for listening.
Good evening, Chris Shilkin. When I first moved here, I met Mike and Bob, and they were talking about the potential of doing some lake development, and I offered up some of the challenges and different things we went through in a prior place where I was doing economic development, which was Devil's Lake, North Dakota. A lot of the same conversations, a lot of the same issues are presented today, much like they were then. And I had sent them to a couple websites and different things that, that was a lake town, predominantly tourism driven. And as a general consensus, I think even now, somebody brought up COVID, but I think also even now tourism, as we're finding out, is probably even more economic development than we thought in the past, as it affects the BBB tax, it affects other people coming to spend their time and money in Watertown. So just as a general thought, they did do commercial development on Devil's Lake, and a lot of the same issues, concerns, valid from everybody. But I think if you were to ask them now if they wouldn't have built the hotel and different amenities on the lake, I think they would have called it a big mistake, because that is a big tourism draw for them. And you don't know what you don't know. But at the time, this sounds a lot like that. But I think when you look at these from a high level community growth, you can't have or want increased tax base and increased sales tax, but have everything stay the same. So from that perspective, I think the project could lend a lot of tools to what we've been talking about. And I've only been here 2.5 years, so I'm sure this conversation has been a long one. But as we talk about increasing these things, I believe this, from a general standpoint, would do that. Thank you.
Hi, Rob Peterson, Chairman of the
H2O2 Watertown 2020 visioning process, which probably needs a new name now because we're in 2020. But just as a reminder for the board, a lot of people got involved with that movement and worked very hard on it. And one of the only things that we never got accomplished was putting in a marina at the lake, because that was one of the things that the consultants said we really needed to put a lot of time and energy into, was utilizing the lake more, and that it was the most underutilized asset that the community had. So as a general statement, H2O2O is excited about the project because of the possibilities of having the marina built, having amenities built, where the lake becomes a destination, becomes an attraction for everybody to use. As I understand it, the wetlands and everything have to be left alone as a green space anyway, so I don't think that's really going to be part of the discussion. And if you look at the build-out area, I think there's pretty good setback from, all the orange zone, there's pretty good setback from most areas. I'm more interested in talking about the fact that, like Chris talked about, if you don't find ways to increase your sales tax revenue, don't find ways to bring more people to town, don't find ways to continue to have big build-out projects like this, then you get stagnant and you don't go anywhere. You know, you're growing or dying. So from the visioning standpoint, we're behind this project, and we think it's a good thing for Watertown, for the lake, and for the community as a whole.
Thank you, Mr. Peterson.
All right, just got to catch my bearings. Mike Lawrence, I work with Bob Drake on this project. It's a project I got involved. Bob's been working on it 6 going on 7 years. I got involved after a residential plan that was developed for this land was failed. It was fought by many of the people that were speaking here tonight. He came in here and tried to do a residential R1 development. It failed. They brought attorneys. They took him through the rigmarole. He came into Harry's, and that's how I met him. He was sitting at the front table, and he said, "I'm giving up." And I said, "You can't give up." And so I got on board, and we've been working 4 years on this. We've been working with the GFMP. We've been working with the Corps. We've been working with the Lake Association. We've been working with some of the neighbors that are in favor. We have not contacted Miss Williams because we're probably never going to win that fight. We're never going to win that battle. The problems that she discussed with all of the problems that were there, that was, correct me if I'm wrong, that was a different developer that got hit with those. It was not Mr. Drake. He purchased the land after that. So that was not on him. We've worked with the GF&P to try to get them to give an easement on those wetlands, not to use them. Rhett Russell, he said, "You can use my name, you can have anyone call me. Those wetlands will not be touched. They're his baby. There's the baby of the lake. The Corps of the DNR would all have to sign off on this." He says they have no interest in having an easement over them. And I asked him for a letter, and he said that their company is more, or their business is more of retroactive. They only send out letters when things go wrong. So we've went through all the things. You know, it is partially on the Compesca master plan. It is on the comprehensive land use. The reason that we included the Reeds and AG, and to be fair, we do plan on designating or giving that road back to the city that surrounds one side of Mr. DeBoer's home. Mr. DeBoer wasn't happy with the road being curved. Mr. Drake went out and bought more land. He paid for more engineering. We straightened the road. We submitted it before this. You asked for our trust in that. It's already been given. It's already been done. It's sitting on engineering's desk. Mr. Drake, because of the size of this, he wants to dig and put in a public-private marina that would cost upwards of $2 million. That's why you need the density. That's why you need the land. We can only put on that land what the traffic counts and will let us. That comes during the prelim plan phase. We still have to engineer this project. We still have to make sure that it fits the amount of traffic that's in that area. This is just the first step, and honestly, we're finding out on the other part, it's hard to make these work. I mean, especially with the CL district, we did wait for that. There is C2 zoning on this. We could have went for C2 zoning. It's C2 between an R3, so step zoning would work. You have to understand that Hidden Valley is an R3. We could build condos on Hidden Valley if we would have bought the N2 lots. That's zoned correctly. The zoning that we're asking for here tonight is not obtruse for the area. It's step zoned. The other thing is, you guys came up with this CL district. You put the stipulations in it to be next to somebody's house. As you are here tonight, we have one property owner. Can you put my map up, please? We have one property owner that's here and one that's not, I've talked numerous times with the other one that it touches. Other than that, where are you going to find a property that's surrounded by a road with a 60-foot right-of-way plus the setbacks that you guys have put in place? I think that as other people said, this is a large project that will affect a lot of people. There's a lot of people that want to be here. There's a lot of people that want to use it. There's a lot of people that want to get onto Lake Compesca. Let me see. Sorry, I just got a lot of notes. As far as having commercial property value go down, Bonnie, you know as much as I do, the land between the houses that appraise between the golf courses and the prop are some of the smallest houses on the smallest lots that sell for the most amount of money. I mean, that's true. That's where people want to be. People want to be on South Lake Drive, a large majority. They want to be around what's going on. So I hope that we can look at this as something that Mr. Drake's taking a huge gamble on. We don't know if it's worked. It's not guaranteed that he spends millions and millions and millions of dollars and this works. He's already into this thing. He bought that land for $1.4 million. Your CL district cuts that in half of usable land. You take that $1.4 million and you cut off $700,000 worth of land that he can't use immediately. It meets the criteria of the new CL district. The GFMP is on board. It increases property values, increased sales tax, increased public access. When I hear people say there's too many people on the lake, I live on the lake. I have 155 feet of frontage. That's all I'm guaranteed, the frontage. I live on a public park that other people are here for. And if we want to improve this lake and clean it out, we need the support of the community. We need that vote. So, and then maybe sometime we'll stop hearing how underutilized this asset is. We do plan on doing a marketing campaign that would include the zoo, the Redland Arts Center, all of those things to try to get people to purchase our condos and come to our community. And that we're going to fund that, and there's a way to grow this community. And I think this is an extremely rare and important point and project to have somebody like Bob step up and go through 6, almost 7 years of progress, get turned down for an R1, get turned down for many things on this project and just keep going. I applaud him. So I'll take any questions.
One of my questions, Mike, is how are you going to access the marina without going through the wetlands?
The grading permit for that has already been approved by the city and the Corps to go through where the wetland or where this is designated currently.
Okay, so you're not going to go through the channel of, the channel of Hidden
Nope.
Valley Association. You're going to go like where that upper left-hand corner is of your thing there?
It's called actually the old Stella May channel. The previous owners, the Williams, had a channel that went back there and did just exactly what we did, but it was smaller, granted. But they had a channel. They had fishing houses. They sold fish out of there. They rented canoes out of there. Many of the things that we plan on doing. This isn't something we're not even reinventing the wheel here. This happened here.
And the GFMP and DNR are all fine with
Correct. Mr. Drake has also got approved in the Compesca master plan. They called for rock docks to improve fisheries. I don't know if you guys remember the docks that they want rocks out into the lake, and then so the GFMP and the Corps has approved rock docks, and the GFMP has actually came out and said that they'll build docks on there for fishing. These are things that Mr. Drake doesn't have to do, but it does meet the needs of the Compesca Master Plan as well.
I have a question for you.
You bet.
Parcel 3 is included in the rezoning to commercial, and parcel 3 is just right away.
Correct.
And it, heard a couple of concerns that it makes commercial adjacent to properties. Would you consider not rezoning parcel 3 and just?
Yeah, I mean
right
it's going to be a right away. Yeah, it'd be a right away anyway. It's already it's the only way we can get there. We had to purchase that road to get there.
Yeah. Yeah, that was just one of my thoughts, is because then if someone is looking at buying, lot 1 of
we would have
the previous division, then they're not buying adjacent to commercial, and DeBoer's property is not completely surrounded by commercial then, and across the street to the south won't be adjacent to commercial either, since that is just right away.
We would have no objection to that.
Thank you.
Like I said, Mr. Drake went above and beyond to try to solve the solutions, to try to fix the mistakes of the past. He's worked with the city, the Lake Association, every entity that we can possibly do. We've crossed all the T's, dotted all the I's. We've came up here and not asked for special favors. We are just trying to move a project forward on this land that has been already tried for an R1. This would have been done 6 years ago if they would have just not fought Mr. Drake. Luckily for the community of Watertown, we're going to get a commercial aspect out here, a marina, and some other things that the public can use.
Mike, this is Diana Ford.
Yes, ma'am.
If the owner has no plans to develop within the jurisdictional wetlands, then why are they being included in this rezoning?
Because of the restrictions on the CL district. They actually, the land coverage that is needed will lock those and secure those even above and beyond the GFMP, because we won't be able to develop them because it is part of the 50% lot coverage that we currently need. When you design the CL district, you put a 50% lot coverage in there. If you want to have more density, you have to buy more land. We purchased the wetlands and parcels from Mr. Dennis Arnold, and we don't plan on developing him. We can't develop them, but that's part of the CL district that you guys just came up with, and that's the solution to our problem. Those are, if you look on the screen, that's what the rock docks would look like, which are approved by the Corps.
Can you go to the next screen that you just popped? Then one more. No. There. Oh, no. So that's what the marina is going to look like, proposed.
Incorrect. No, the marina will come inland.
I have pulled up the Lake Compesca Master Plan.
Yep.
This is an example of what a marina could be.
Mr. Chair?
But that's not the one that you're planning on.
Yes, sir, Mr. Case.
Mr. Chair, I don't mean to discount what my other board members are saying, but we are getting to a minutia of a conditional use or other permitted use. To me, the issue is whether or not the comprehensive land use plan, the master plan of the lake, and is an appropriate place for this commercial lake district. We had this conversation when we talked about the campground that was property zoned on the other side of the lake. We were getting into the minutia of what could possibly be, but there's a whole litany of uses that are listed in the CL, and Mr. Drake theoretically could walk out the door tonight and sell the property to somebody else, do any one of those other uses that are listed. So I caution us to get into, understanding or trying to look at the design of something that we haven't even seen yet before us. The question is more or less whether or not this specific piece of dirt is the appropriate place to have the commercial lake district tag attached to it.
I agree with you, Todd. That is the question. And then the question also is, should the entire property that's being proposed be CL, or is it all or nothing, or can it be partly designated CL?
Yeah, I think that's the discussion as opposed to what's going inside the box.
Right, I agree. It's what's going to be designated CL. All of it, part of it, what's going to be parceled off and left something else. The wetlands are an issue. As a Board of Adjustment and as a Plan Commission, we have often stated that someone who buys a piece of property looks around them and sees what the zoning is, and that's something that we take into consideration when we make these decisions.
And I would agree with that, Diana. We're positioned between a C2 and an R3. The perfect step zone between a C2 and an R3 would be a CL.
I'm only stating that, as Todd was pointing out, these are the points of discussion that I agree we should be having, rather than, maybe the minutia. These are the things that we really need to talk about. What really is appropriate CL? How do we look upon the statements the board has put forward in the past as to people purchasing property, how they can rely on what's surrounding them? The wetlands, these are all the things that we need to try to figure out here.
Yep. And as a developer, we also look at master plans and we look at comprehensive land use plans and we look at things like that try to drive our decisions on which should go there. I mean, we pay for these studies. There's $90,000 Lake Campestre master plan study that was paid for by taxpayers that pegs this for mixed use.
And it also pegs those wetlands as likely not being considered commercial.
Yeah, the wetlands can't. The wetlands cannot be. I mean, we offered to give an easement on the wetlands to the GFMP. We went to. I met with Rhett Russell on a Wednesday morning. He said not needed, won't accept. They will not get developed. He said the easement was not needed. He would not accept one, and the wetlands cannot be developed.
Who said that?
Rhett Russell from the GFMP, Game Fish and Parks. I asked him to get it in writing, and he said the GFMP is more of a retroactive organization, and they only write letters when things go wrong.
That's the problem that I have, because who knows how long this person will be there. Someone else could have a totally different opinion and different outlook on that.
I think we have to go back to what we can control, and what we control is what's in our ordinance. And if the applicant comes in and is looking at zoning this entire area C3, and we know that 50% of the property has to remain in a natural state, then we know that these areas cannot be developed if they want to move forward. So you almost have to take, you color out the area that could potentially be developed, and then the other part isn't. So, I mean, our ordinance is going to dictate what happens to this property, whether if it's zoned ag, we know it's not. If it's zoned CL and they plan on developing any of that part, they're going to have 50% of the land set aside for non-impervious surfaces.
That was one of the benefits that we had when we talked about the CL district and putting that 50% impervious in there, was because it would necessitate them to have a larger plot of land and to maintain more of the natural environment within that land. Much more than we have required anywhere else in the community.
If we can all remember when we were having those conversations only several months ago, was that as like I said, we weren't looking at wanting to do little spot zonings of the CL district around the lake. We were trying to look at finding areas that would comport with the land use plans that have been developed by the Planning Commission and the City Council and made available to the public for many, many years. And at the same point in time, trying to, if we're going, if not here, then where?
Mike Lawrence again. I just talked to somebody and he kind of gave me a compromise that might work. We rezone everything else that's not wetlands, but you let us use the wetland area as our lot coverage. Wetlands stay the same zone, but we are able to use the square footage of wetlands as in our calculation for our lot coverage of CL.
So then the entire land could be covered with impervious surface?
Correct. That's how the CL district is set up.
No, you say the water will be your 50%?
No, the wetlands would be, well, I mean, it's a 28 acre parcel and we only have 10 point some acres of, so, I mean, if you, yeah.
So if you use the water in your calculation of the land that has to be pervious, then the remaining land will be mostly impervious?
Correct.
So you would leave the wetland zoned ag?
We would leave the wetland zone as they are, as long as they acted the same as they would as if they were zoned commercially.
So you're saying, Mike, in the calculation, the ag lands would be combined with the CL lands for the calculation of impervious surfaces, but would retain the ag status to restrict the potential uses.
Mr. Chair.
Correct, yeah. I just had to make sure Bob was okay with that. And kind of flew off the handle here.
Mr. Roby?
That's certainly a possibility, but that would require a variance from the commercial lake zone.
Then we would ask to go forward because of the timeline. Yep, sorry.
That would require a separate action.
And it's
Let me back up. This is Todd again. I don't want to be creating a zoning district where we're going to have to come in and ask a variance. That just seems asinine to me. And to me, again, if the proposal is to use X amount of acres for whatever type of commercial, residential, mixed-use development on the CL district, they can't use those wetland areas anyway. They need them for the match.
This is Jeff Brink. I think we should just scrap that idea. I think it'd be really confusing to have R1 zone be covering the CL's requirements. I mean, I think we rezone it all. I don't think we should try to piecemeal it and make exceptions.
Agreed.
I guess at some point, you do have to trust the Corps, the DNR, I mean, if this was all, if these wetlands were just land, we could still ask for the entire parcel to be rezoned, because we would need it for the 50%. Luckily, they're not, and they're controlled by multiple entities, including the city. If the city would request an easement to them on these wetlands, we would provide them with one.
The benefit we've got again here, given the nature of how we've built out that CL district, is the harsh restriction on that coverage. So by looking at the entire parcel and subjecting them to that 50% requirement where they have to reserve this land to offset the building that they want to do, it further restricts the future ability for them to do anything with the wetlands.
Agreed.
Thanks for that analysis, Blake.
I have a question for city staff. This board recently approved the preliminary plan for the right-of-way. Has that been approved by city council?
No, because that's just a preliminary plan. And then the property is already platted, but I can show you guys, because with the motion that was made upon the approval of the prelim plan by the Plan Commission, was that we work with the developers and then also with KC DeBoer as the adjacent landowner on realigning the street. So I'll just show you that, what they've done here. It used to curve when you guys saw it last. It curved over to the west, which impacted Mr. DeBoer's property. And then now they've straightened it, so it will not be in the backyard.
Okay, thank you. And I guess the point of my question is we approved a preliminary plan for a road up there. Next will come the plat of that. And I guess the question is what do we want built next to that road? We have, there's a lot of ag in parcel 2. Do we want any of the ag uses? You can look at those in our ordinance book 21.12. And then we have R1 in a majority of parcel 1, and we have C2. and the question to me is, do we want to keep it as is, or would we rather have the CL uses? And you know, I think we've established as a community through our comprehensive land use plan that we've thought that this portion of the lake north of parcel 2, according to our maps that are in our packet, was anticipated and planned and approved to be mixed use or commercial lake type stuff. So I think that's really where we should be trying to focus on. Is that really, now that it's in front of us, is that really what we want to approve? And
I would think, since we just updated the comp plan in 2019, and then if you remember why the push to create the CL district came about was because we had the rezoning happening on the north side of the lake, and that was highway commercial. That's appropriate because it is adjacent to Highway 20, but also in the Lake Kempesca master plan there was the community wanted commercial development, and a marina, restaurants, everything that actually, like Stony Point, this development would be proposing, was in the Lake Kempesca master plan. So then we took the time and created the CL district. And so if it's not going to work, are we going to fix it?
Mr. Chair, is the public hearing still on, or is this on board discussion?
Public hearing is still open technically. Is there anybody that hasn't spoken in the public that would like the opportunity before we close the public hearing?
Brandy, would you pull up that road change? Bob Drake. When we did this plan, originally the reason we curved that road was so that Dennis Arnold could have a lot next to his pond out there. And when Casey came to change that, to straighten that road, we ended up purchasing Dennis's ground in order to do that. We also needed the wetlands for green space to match that 50% that you're talking about. It did create a little space on the left side of the road. And all of that has to go through a preliminary plan or something in the future if we're going to develop it anyway. And so when we get in and talking about these spaces, I just wanted to point that out. This is just the rezoning part. It has to come forward anyway. So anyway, thank you.
Anybody else there in the room to speak in the public? Let me know if there isn't. Brandy, I can't quite see the room there from my home.
Bob has one more thing.
One more thing. Merlin brought up the filling of the wetland. LATI was doing the Marina A, which is the entrance coming into the wetland. They filled that portion up, but that will be all excavated back out. They did that in order to access, to be able to do it, so that he knows what it is.
I'm glad to hear that, because we were really concerned about that being done there. Where else would it be done?
Yeah, no, that's the only spot, that's the entrance to Marina A, and that's where it comes through. And then we're planning for a rock dock out there, and then one over on the point, so that you know. Thank you.
All right, I'll go ahead and close the public hearing.
Mr. Chair, I'd like to make a motion to approve for purposes of discussion.
A motion on the table by Mr. Case to approve as presented.
Ford seconds.
And a second by Ford.
This is Jeff. Could we less out parcel 3? The applicant said they were willing to do that, and that's just right away. That would be, so then there's not commercial adjacent to some residential houses or as much.
Is that a motion to amend the motion?
Yeah, I'll make a motion to amend the motion to exclude parcel 3.
Do I have a second for the amendment?
Second, Case.
Right.
We'll take a roll call on that amendment.
discussion first, sir.
Discussion, sorry.
This is Bonnie. I would like to see us also take out parcel number 2, because that does surround Mr. DeBoer, all that with the residential property going to a commercial.
Mr. Chair, this is Kays. I would like, can we take them in pieces?
Yeah, I agree. The discussion on the amendment to remove parcel number 3 first. Is there any further discussion on this item? Jeff, I think you were succinct in the reasoning for this.
Yeah, I'll reiterate it. It's 66 feet wide, which is exactly what the right-of-way width is. And typically when we rezone, we go to the center of right-of-way, so I feel that just rezoning just right-of-way isn't appropriate. And by not rezoning it, it keeps Lot 1 of the old division, Prairie Hills Development, second edition, that will no longer be adjacent to commercial. One less side of DeBoer's property will be adjacent to commercial, and all of the properties south of Prairie Hills Avenue will no longer be adjacent to commercial. So that was my reasoning behind supporting not rezoning that piece.
Any additional discussion on this amendment?
Mr. Chair, if I may, just question the applicant. I don't have the numbers. I didn't calculate these, but is the right-of-way included in your calculations, your 50/50 percentages? Do you guys know that?
I'm guessing it was, but I don't know that for sure. But
Okay.
there's no problem.
We have no problem.
I just want to confirm you were aware that that would affect your percentages. Okay. Thank you.
If there's no additional discussion, we'll take a roll call on that amendment.
Kays,
Yes.
Spear, or Spire,
Yes.
Hanson,
Yes.
Dolly,
Yes.
Aletsky,
Yes.
Brink,
Yes.
Ford.
Yes.
Amendment passes. Ms. Aletsky, I believe you had a comment related to parcel number 2.
Yes, I would like to see parcel number 2 not to be rezoned to the commercial district because it does surround residential property.
Need to call for a second.
I'll second.
Do we have a second?
Brink seconds.
Second by Brink. Discussion.
This is Kays. I'm going to disagree. I think everything's in place. We know with the commercial lake requirement for the 50/50, and these lands would be used in those 50/50 calculations and would remain, are going to need to be remained from the impervious requirement. So I don't know why we would need to do that.
Yeah, and I guess just to take that a little bit further, I think it actually protects this land additionally from a long-term development standpoint by including it into CL. Because once we've built on the other area within that CL zone, you have to continue to maintain that 50% coverage, right? So the long-term inclusion of this property within the CL calculation for 50% is a long-term reservation of the natural order of this wetland.
Right.
And if you look at the permitted and conditional uses, it looks like there's enough area outside of the wetland in parcel 2 for a lot. I think I would rather have a CL use there than agricultural use, just looking at the permitted and conditional uses.
Any additional discussions on this amendment?
I would just like to point out that open water and wetlands are normally not considered pervious. And I think that's something that we haven't directly addressed in our ordinances. But I looked up the TR 55, which is a drainage manual, and it showed that wetlands and open water are considered impervious. And if that's what we're talking about, the 50% is 50% has to be pervious. So an impervious surface won't count toward. So there.
I've seen that, what the mayor is talking about here, I've seen that in other zonings, in other counties, in other states. And when they say, okay, you have to have a 2-acre lot and you have a couple of spots of water, that's not included on your 2 acres.
Right, so if, and he said his intention was to completely pave the dry land and, you know, or mostly, because consider that the impervious and the wetland would be the pervious percentage to make up the balance. They need that to make up the balance. But I don't know if they understand that the water is counting against you if that's your intention. And so you're going down the wrong road if that's what you're thinking. That doesn't benefit you, that hurts your calculation because it's already impervious.
Mr. Mayor, Madam Mayor, that is in the zoning code, or where is that?
That's not, we don't address that, but that's just I mean, I've done modeling of water courses, and when you encounter open water or wetland, it is considered impervious. It is not considered pervious. It doesn't soak in and go away. It immediately raises the water level when water falls on water. So open water is not pervious. Open water is impervious. So just make sure you know that, because our definition doesn't say open space. It says impervious.
And I have asked that months ago from your city engineer and your planner, both confirming that it would be used in our calculation. So that is where that came from.
Oh, I didn't realize that.
So I think that the discussion evolves into the intent behind the term impervious in our CL district. Because right now it says impervious areas shall not exceed 50% of the total lot area. I would beg the question, and this is something we could consider a zoning amendment to, is the intent that that land be impervious, or is it the intent that that land be open space or green space or undeveloped, or another term that doesn't mean the technical intent that the mayor has described? Because water is not, would not be considered open space, green space. It is impervious. You cannot, water will not infiltrate water, just like water will not infiltrate pavement. And so, from a technicality, from a hydraulic analysis, that is true. Now, whether that's the intent of the language in this section of the ordinance, I think is the bigger question we need to ask.
And I think if we went,
I'm sorry.
You go ahead, Todd.
This is Caves, and I believe Commissioner Dolly will probably also echo this, being that he was there at all the meetings that I was at. I thought in our discussions, and I think also Commissioner Ford would attest, that we were talking about not having things being developed on that we would have that as more of an open space, separation, green space. I don't think we were getting into the technical engineering jargon of hydrology and hydraulics and all those types of things. I think we were just thinking from the perspective that we weren't going to see anything developed there. We wanted it to be open, and whether that be water or grass or dirt. I can tell you, as a practitioner of planning and zoning for more than 30 years, that most counties, if I have a lot that's a 5-acre lot and there's 3 acres of water on it, I still have a 5-acre lot for the purposes of meeting lot area requirements. So I will disagree a little bit with my counterpart on the board. I can tell you, I think the intent is to keep it as an open space. If we want to amend it later, I think we can amend it later. I don't think it really has to stop progress on the vote tonight.
Yeah, and that's.
I would agree, Todd, with the intent of what we had talked about there was really in around, preserving a natural environment, particularly at the lake, and some of the discussions at that time included talk of wetlands around the lake and preservation of these natural environments. So I agree. I don't believe that was the intent of the language when it was drafted.
And when it comes to the administration of that component of the ordinance, at the time of the preliminary plan for the rest of this property, that is an amendment we would want to bring forward so that we can then administer that regulation according to the board's intent. Because as it reads right now, I could not administratively approve this calculation of 50% rule in the way that the developer's wanting to because of the technicality of that term impervious.
And any of our discussion that we did have with the CL district as far as the subcommittee and then at Plan Commission, when we discussed it, it was not the technical that would have been good to know. I didn't know that that's what it meant. And I think that the group, the subcommittee, they were thinking reserving open space, not paving. So if that's something we can, and I believe that's where we're all at, and we can bring an amendment forward with the actual intent.
And that is why we brought up CL and not C2. Or C3.
Mr. Chair.
But yeah, that would be a necessity before we do any preliminary planning, and it doesn't necessarily have bearing over whether or not it's appropriate to proceed with the rezone of CL, right?
Mr. Chair, call a question on the amendment.
Yes, sir. Let's proceed with the roll call vote.
So this is to exclude parcel number 2.
Yes.
Kays,
No.
Spire,
No.
Hanson,
No.
Dolly,
No.
Aletsky,
Yes.
Brink,
No.
Ford.
Yes.
Motion does not pass.
So down to the amended motion, we have excluded parcel number 3. Motion to exclude parcel number 2 has failed. So the motion on the table is to proceed with rezone of CL for parcel 1 and 2.
You guys
And
are
that
ready
motion
for a roll
is-
call, or do you want
Any
to?
additional discussion from the board? I know we've talked quite extensively already.
Could you specifically repeat what the motion is? I think we might all be just a little confused.
So the motion,
My motion is to approve parcels 1, 2, and 3. However, that's been amended to now parcels 1 and 2 would be moved to zone CL.
correct.
Brandy, could you just
Thank you.
outline parcels 1 and 2, please, on that map for reference?
Yep. So this is parcel 1, and then this is parcel 2. Parcel 3 that will be excluded from this motion or in this action is this right-of-way parcel.
And as Jeff had said, parcel number 3 is what will eventually become the road.
Correct. Yep. That'll be where the street will be constructed.
Any additional discussion before we take a roll call vote? All right, Brandy, we'll proceed.
Kays,
Yes.
Spire,
Yes.
Hanson,
Yes.
Dolly,
Yes.
Aletsky,
No.
Brink,
Yes.
Ford.
Yes.
Motion passes.
All right,
As
thank you,
amended.
everybody. Brandy, we'll move on to agenda item 6B whenever you're ready. Resolution 2020-29.
Okay, thank you, Blake. So this is commission consideration of resolution number 2020-29, a zoning text amendment to chapter 2102, administration and enforcement of the revised ordinances of the city of Watertown. So this goes back to discussion we had. Thank you all for coming. Okay, so we talked about this at the June 4th meeting about as far as our certified mailing or our notice to adjacent landowners. And that was new business, so we just wanted to create consistency between when we were sending out notice to the adjacent landowners for the Board of Adjustment items, which are the variances and the conditional uses. And then for the Plan Commission items, which would be the annexation and zoning and rezone, which in ordinance is just considered amendment. It's an amendment to the zoning ordinance. So what we decided on there, and this resolution is just memorializing that to create the consistency. And so it'll be, notice shall be given to all landowners within 250 feet, including the width of the public right-of-way from the legally described property requesting a conditional.
Say Brandy, can you share that on the Teams meeting?
Yeah, sorry, didn't get down there yet. Okay.
Thank you.
Yep. Sorry about that. So this is where, and now this is the same language for all three items: conditional uses, variances, and amendments. So we would send notice by first-class mail to the landowners within 250 feet of the property that is legally described that is being petitioned to change. And I know that we did discuss about having the language in there of adjacent, so sending notice to the adjacent properties or properties within 250 feet, whichever created a greater number of greater notices sent out. But really, every time that you go 250 feet from that parcel, you're going to hit all adjacent landowners, no matter.
Yeah, I think the question was around conditional uses and the potential for a conditional use to be bounded within what would be the full legal description of that land, right?
No, it would just be the legally described, not the parent parcel, just the legally described portion of the property. And that's where the confusion was coming from, is that if we were interpreting that it should be taken from, and for example, just because we're familiar with Compesca Dunes, we'll go over there. So Paul Carlson owns all of Lot A, but he's rezoning to R3 just in that corner, where the 250 feet comes from state statute that they would be able to appeal a decision, assuming that that's because they feel aggrieved by the distance, how close it is to their property. So now by saying the legally described portion, this will be replatted before any building permit would go on there. But as far as notice for these hearings, it'll come from just the legally described portion that is changing, and then the landowners within 250 feet of that parcel.
So I guess my question was, and we've seen this before, where we've got a conditional use for, say, a bar or tavern, and we limit that conditional use to only a small area within that legal property.
Then it still would be 200.
In that case, it still goes from the bounds of the property, right? Not the bounds of where we're saying the conditional use can apply.
If it's legally described, I mean, it should just go from that area. You're still going to hit all of the same landowners, though, because, I mean, it's 250 feet out.
I think, Mr. Chairman, if I may, to the chairman's point, Brandy, I'd almost look for Matt for some direction on that, because I understand what the chairman's saying is if you have a bar looking for a conditional use or a building looking for a conditional use within the structure, and that conditional use is specific to a room or a portion of that structure, does the conditional use then carry, Matt, with the parcel that the structure is on? I assume that it would, but there's limitations with the conditional use that apply to a more specific location within the parcel, but would still generally apply to the parcel.
And I guess the concern would be if you got a very large plot of land. So look at the mall property, for instance. And if a single store location within it wanted to apply for a conditional use for a bar or tavern, 250 feet could potentially not include neighboring properties that are adjacent if you have a particularly large plot of land.
But then it gets to if we're keeping it consistent, and we are saying that people within 250 feet should only feel aggrieved, I'm not sure why that would matter then.
Well, I think we're messing up what aggrieved is. I mean, the aggrieved is the only aggrieved status happens with zoning. And zoning is if 40% of those adjoining property owners or whatever are within 250 feet feel aggrieved, they can appeal it to the city council, and then on a supermajority vote, it has to be, it can be overturned. When it comes to variances and conditional uses, the aggrieved status goes straight to circuit court. And so I think the question just becomes, I think adjacent is probably appropriate on conditional uses and variances, just from the perspective that you want to know what's going on next to you, because you see it in large lots out in the country, especially. I own a quarter section. I'd put something on the inside of the interior 40, and I got a 250 foot. Heck, I own all the land around me, so I don't have to notice anybody. So I think it's not a bad thing, the adjacent or the 250, depending on whichever has the greater number.
But then we get.
Or you just say adjacent and those properties within 250, and I think you get what Blake wants.
Yeah, you're going to get everybody that way.
But that I think opens up. So are we sending out notice to people from the legally described portion, or like the platted lot or the parcel, like the parent parcel? Because
I thought, Mr. Chair.
Yes, sir.
It's my understanding that we landed on this was that we would do whatever. In each situation, we would err on the side of the most notice.
Yep. That's where the original language, the either or, had come from. But to Mr. K's point, if you do an and, if you just say adjacent and 250 feet, doesn't that just capture everything then?
Yeah, and I think that Brandy's point on why she was giving this another look, and she had talked to me about this as well, I think it all depends on where we're going from. If we're going from a small area within a parcel, like the mall property she has outlined there on the screen, if you're going to take it from that red square because that's where the bar and tavern is, rather than from the blue line, then I agree, we need to do adjacent and 250, because the 250 is not going to reach as many people. But if we're going to, by a standard, take it from the parcel line, then the 250 is always going to reach the maximum.
Right.
Does that summarize what you were trying to get at, Brandy?
Yeah, it does. But I think that it's like where do we draw the line at, like where are we going to send the notice from? Is it because even if this is where the legally described, if this is where the bar tavern's going, so this is adjacent then.
But 95% of your properties are not going to be a large property where I've got suite type developments. They're going to be individual properties that there's going to be a single use on that property. I mean, the mall or strip mall is really those are going to be the incidental oddball situations where you're going to have to end up sending more notices than you would under normal circumstances.
I just don't want to create a situation where we're potentially not sending notices.
Right. As staff sending out the notices though, it's still, that leaves it basically where we're at today, because that gets down to where are we drawing the line? If it's the legally described portion, it doesn't matter then if it's within if it's within a quarter section or not. But that's the main premise then, is are we taking it from a parent parcel or the entire lot, or just the portion that is being changed?
Seems like in whatever situation arises, whether it's adjacent or 250 feet, or if it's a parcel within a large, or it's a legally described section within a large parcel, if you just err on the side of sending out the most notice, you'll have your answer every time. You'll take 250 feet from the largest piece of from the piece that provides the most notice.
But if it's in the middle of a quarter section, then anything adjacent is owned by the same property owner.
Well, let's get back to the conditional uses and variances. I mean, I think we're making a mountain out of molehill. You got 95% of the parcels in the community have a single use on them, right? And so it's real easy. I take everybody that touches my parcel and everybody within 250 feet. You show that on the June 4th meeting. That's all I got to do. It automatically selects. I've got a use. I've got over there by the Dairy Queen on Kemp. You've got what was it? An alcohol establishment inside of a laundromat.
Mm-hmm.
So you take that little section there. The thing is, you're probably, if you went 250 feet from that, you're going to get everything. The problem that you're going to run into is places such as the mall and a few other, maybe it's the school or something like that. But I think by and large, it's adjacent landowners are the ones that are probably the most ones that you should be most concerned about what's going on next to their property. Whether that use is happening inside the quarter section, which is really not going to happen very often, or inside the middle of the block. If I'm less than a couple hundred feet away of something that's going on, and I just happens to be, I don't get the notice because I'm 251 feet away, and because it's going on in the southeast corner of a 350 square foot block, 350 foot area block, I don't get noticed.
Did you have a suggestion on writing that then, Tom?
I still think it's adjacent and within 250 feet of the legally described property. Now, I think the legally described property is the property that it sits on, whether that be lot 1 or lot 5 or lot 10. If it's a store in the mall, where the mall is still located on lot 5.
So your proposal then, for the mall situation, we would go from the bounds of the entire mall 250 feet out?
Yes.
And I feel like that's arbitrary. So I'm like showing this as just a random example. If it would be, so the only thing that's changing would be, and I guess just to say that people would get noticed, say that parcel is changing. So it would be, so are we taking it from the legally described parcel, like we had discussed, or are we taking it from the parent parcel? Because then we're notifying all these people that are like a half a mile away.
In that scenario, Brandy, I guess the way I would envision that, and Todd, I don't know if you're on the same page with what you were describing, that piece you have highlighted in red, if that is its own parcel, and if that is the parcel having an application against it for a variance or a conditional use, that would be the boundary we would use to take the 250 from.
Right.
Agreed.
But it's the same thing as if
the whole blue area was a single legal lot, definition, then you would notice the entire area.
But what if it's a legal description that they're going to replat, but they're not going to replat until they get the zoning changed?
Then we'd have to go from the parent parcel.
See, that's.
But you're not required to send on replats under the existing ordinance, are you? You're just doing that out of courtesy, correct?
No, because you can't have split zoning on a lot. So if they're rezoning a property, they're not going to plat it until they know if it's rezoned. So it would be from the legally described portion. Because why, it doesn't affect, if we're saying that people, not even aggrieved, but people within 250 feet would feel affected or that would want to know what was happening. So these people, it's a half mile away.
We got to remember though that all this stuff, this has to do with giving notice. So everything is in the newspaper anyway. So I don't know why we would try to restrict what we're sending out notice for. What's the issue of just sending it out to a broader audience? That's what I guess we should err on the side of notice. We never get in trouble for providing too much notice. I'll just say that.
But I'm trying to get to where we're completely consistent.
And consistency always isn't correct.
Okay, fine.
Yeah, I think the struggle came in with this example, the first example, the Compesca Dunes, and different staff interpretations of who those mailings go out to, because we did have a parcel that had a proposed conditional use on it. And correct me if I'm wrong, is that platted yet, Brandy, or no?
No, that's Compesca Dunes.
Yeah.
Not yet.
Okay. So in that case, I guess that lot wasn't platted yet, but for the sake of discussion, let's say that southeast corner was platted where the proposed storage units are going. The discussion was, does the notice go out from that parcel boundary or from the whole parent parcel that the same gentleman happened to own? And I think that's what Brandy's wanting to get clarity on, the board's intent in that scenario. What, staff could use some direction there on how we'd want to proceed in those scenarios.
I'm just gonna, this is the last comment I'm gonna make regarding this. In this situation, if the whole parcel was zoned agricultural, and all of a sudden they want to take the little corner where we're gonna put the storage units, and you're gonna rezone that to R3 for the purposes of storage units, I think everybody that touches that property on the south side of 12th Avenue should get a notice, even though they're further than 250 feet away.
So they did get notice
I'd
when the
agree.
preliminary plan was coming through because it was adjacent.
Yeah, but the zoning is more important than the preliminary plan.
But then where do we draw the line for the distance? I mean,
You're not required to notice a preliminary plan in your ordinance, are you, in the subdivision regulations?
no, we just do that out of courtesy.
That's courtesy. So I mean, I'm saying you're making work for yourself. The more permanent solution right there is the zoning. And once you attach the zoning and then the preliminary plan, I mean, it's nice that you do that. You're not mandated by anybody to do that, state or by local ordinance.
Just, and we'll go around with it. I just think as staff actually sending the notices, we're not, and I don't want to restrict notice. I want to people should get the right notice, but I want consistency. And I'll leave it at that.
So in terms of the amendment before the board, Brandy, does the amendment still stand as is and doesn't necessarily change? It's just a matter of how we administer the amendment to the ordinance?
Well, I specifically put in here because of our last discussion on June 4th that I did go back and listen to, and we talked about Compesca Dunes and this situation. And so I did put in here that it would be including, so notice shall be given to the landowners within 250 feet, including the width of the public right-of-way from the legally described property requesting a conditional use. So that would be what was on the application.
But the whole parent parcel was that whole thing, not just the corner, right? So then if you would have went from the parent parcel, it would have gone to all of the homeowners on that south side, correct?
Yeah. But then
So if
that
you went
goes
from
into
the parent parcel, it's going to go to a bunch more. I mean, you're talking about 50 different people.
The other issue with going just from the legal description is somebody could try to play games with, if I have a 2-acre lot and I need a home occupation, but it's just going to be, I'm just going to use my home occupation for a small room in my basement, and I get a legal description for that little portion of my house, so I don't have to send notices out to as many people. That's an issue.
Yeah, that's my concern, is creating a loophole where we potentially don't send notice to some people that we should. And I don't want to necessarily, go the opposite direction. And if we go from the parent parcel now 250 feet off of this huge chunk of land, we're noticing, 200 people.
I guess my problem gets back to this whole question of legally described parcel. I mean, the parent parcel is the legally described. If I haven't platted the property, then it's not legally described.
Yeah.
So you have to use the parent parcel.
Okay, so that's where we'll go from then. It'll be from the parent parcel. So I will change that in this ordinance. I just want consistency. The more, the better.
And I'm not sure parent parcel is the correct term to use if we change that. It's more the platted property.
I personally like legal
Some
lot
property
of
is not
record
platted.
as opposed to legally described property.
I agree with, I agree with Mr. Kays, the way that he described it.
So the parcel, because sometimes it's not going to be platted.
But it's still a legal lot of record. It's on file with the Register of Deeds.
Okay.
I do want to make a little comment. I understand the reasoning for certified letters, and I wasn't there at the June 4th meeting. I apologize, but I did watch it. Part of the reasoning behind the certified letter process has always been, especially in Board of Adjustment actions, if we're requiring it to be mailed, how do you have proof that the mailing was done when you get deposed? And basically that's happened to me before in the past. So if we get rid of the certified letter, which I'm okay with, then we need to have an administrative process internally where you will have an affidavit from the zoning officer or the urban planner attesting that these letters were sent to the following addresses, because someday you will need that when you get sued.
Well, then
What a
let's.
happy note.
So should we just keep them certified?
No, I don't think you need to have them certified. There's an extra cost. It's kind of nice to have it, but I've also been involved in court cases, and it's been upheld that as long, Brittany, as when you send out those notices, that you create an affidavit that you sign that the notices were sent out on this day, and that's punishable under perjury. So I think that would suffice.
Okay,
Good with that?
sure. I wanted the ordinance amendment to make it more clean and consistent, where if it's, and I don't know what that'll look like. It'll just be one page to say when it was sent out, but there's actually really never proof then that they did receive it. I just don't want to create more work or confusion with this ordinance amendment. This is.
No, I think it's good. I think the more the notices, the better. I think, again, and Matt has told you, the only real requirement in statutory is that it needs to be a public notice published in a newspaper 10 days before. We're going more over and above. And if we put the sign in on the conditional uses, that's also a good notice requirement. As long as you are doing due diligence and you're attesting that I sent the letters out, I think, we can't stop or help the mail getting there.
Yeah, the purpose is we're trying to get more notice out there, but we don't need to create a process that is so burdensome that we can't keep up with the volume of notices that we need to send now, right? And make this unmanageable.
Good point.
Yeah, under statute, the only notice evidence that we would ever need is that publication record from the newspaper. But yes, the more the more notice, the better. So we could implement an affidavit process when those get sent out. It'd be pretty easy.
Yeah, because when you make a requirement that mail has to go out, and Matt will tell you the first question they're going to nail you on is going to be, did you follow your process? Well, yeah, I mailed it, and somebody says, well, I didn't get my letter. Well, that's fine as long as we have some sort of a statement saying that we did what we said we were going to do. Whether the mail got there or not, it's really not on us.
Can we talk about the sign aspect, the conditional use?
Yep.
In the ordinance, it just says the sign must be at least 24 inches wide, 18 inches tall, with bold lettering to inform the public. We talked about having a standard that the city may supply as far as what the sign needs to be. What's the thought on that?
Is that something more beyond just, we say at this point, I don't mean to talk over you. The requirement is 24 by 18, which is statutorily required. We can do that, and then can't we allow staff the discretion to determine what the color of the sign should be, how it gets implemented, how it gets placed on the property?
I mean, personally, I'd just like to see a template that we have and can supply to people so that there's consistency and we don't have everybody out there like making their own signs and everything is different.
Yeah, I agree. And maybe, is that something that the city has to pay for? Do we just, absorb that with fees or?
I don't know, but if we're going to have a template and we're going to provide them, whether they pay for it or we provide it, I think we should note that in the ordinance as well, that template should come from City Hall.
Yeah, I know that most communities that have this requirement, they have in South Dakota anyway, they have their own signs. They hand out the sign when you apply for the conditional use permit. The applicant's required to post it and bring it back, but the sign is given to them by the city.
Right, and in the discussion on June 4th, that is the direction that we talked about before we had added this, and then you can see I attached what the sign could look like, and then it would be supplied by the city. It's a public service, so it would be whatever cost up front, but it would be for the greater good of the community. And council will also weigh in on this, and if they don't want the city to pay for them, then they'll have to furnish them.
Would it make sense though in the ordinance here to state something about this being a template or a sign provided by the city? Because to me right now, it reads almost like somebody could just go make their own sign and put it up.
Yeah, we could add that.
I don't know the best way to word that.
Well, and I guess if they want to, do we care? I guess, again, back to consistency, I suppose we can say the city will supply a sign.
Because it is a public service and we're trying to notify the public, and so if the signs all look the same, it's something that everybody can recognize.
Yep.
And if somebody just takes a piece of tag board and writes conditional use on there, whatever, I mean, people are going to think it's a garage sale sign or something.
Will the city also require to have the two posts like that? I think it's a good idea to have the two posts, but will the homeowner have to provide the two posts too?
Why can't we just say a sign provided by the city must be posted by the applicant and we're done?
Yeah.
And I guess,
and then the standards can be whatever they need to be.
or if we have two posts that we give them to.
So, Mr. Chair?
Yes, sir.
Bill Spire here. So my only concern would be is if you leave it up to the discretion of the applicant for the conditional use, how that sign is going to be placed, where it's going to be facing, the visibility of it, and so forth is also going to be subject to their discretion. And I'd rather see it where the city was the one that was providing and also placing, and then that cost would be, upon the applicant for the conditional use.
That is a really good point.
Yeah, definitely.
And it could be something where, maybe staff out in the field that they could go and post that, and that it would be consistent and in the most visible place, and not leaving that up to the applicant.
And not in violation of our sign placement ordinances, right?
Yes.
Yeah, I would express agreement with that logic. I would express concern over just the staff availability to do that at this point. In all honesty and transparency, it is another task that we would have to put on an already taxed workforce in the engineering and community development staff members. I have seen instructions given with the placement of the sign in other communities. Like's been referenced already tonight, where the city does provide the sign. They hand them the sign at the counter when they pick up when they fill out their application or paperwork, and the property owners are responsible to post it according to the instructions provided with the sign. There's ways to do it that way. And then in regards to the posts, I've seen some heavier built sandwich type sign boards made by communities to where there aren't any posts needed. There's lots of ways to get creative with that sign and how it's placed and by whom it's placed. But I agree with the concept of somebody knowing where it's supposed to go, placing the sign. I completely agree with that. I would just express concern over, like we talked about in the last meeting, trying to streamline the process and keep it efficient for staff processing purposes.
Couldn't we just, I mean, we've got a we got a GIS, you pull up the picture, you point to the spot on the map, and you just tell the person that's where they got to put it?
Yeah. Yeah, and we could just have a procedure, like an instruction list that we give them when we give them the sign.
Right. I think, again, Mr. Chair, I'll call the question on this. We're getting, the question is, do we want to, I guess the amendments would be that number 3 under conditional uses, and number 5 under variance, and under procedure, it would say adjacent and within 250 feet, and that a sign provided by the city must be posted by the applicant. Would be my amendments, sir.
But
So you have a amendment motion on the table?
Oh, and I'm sorry, the other one would be changing legally described to legal lot of record.
Yep.
I'll second that.
Motion and a second. So is that just an amended motion, or are you?
I can't remember who made the original motion.
I don't believe we have an original motion.
We haven't taken an original motion.
That would be my original motion.
Amended motion? Okay. Or just an original motion with those amendments?
My original motion with amendments. Not amendment, it's just the motion, excuse me, I'm sorry. Getting punchy.
Yeah, you're right. You're right. It's been a long day. All right, any additional discussion on this before we take a vote? As a matter of clarity, I don't know that I opened the public hearing on this one. So before we take a vote, I'll open a public hearing. Is there anybody to speak on behalf or against?
No.
Then I'll close the public hearing and we'll take a roll call vote.
Kays.
Aye.
Spire.
Yes.
Hanson.
Yes.
Dolly.
Yes.
Aletsky.
Yes.
Brink.
Yes.
Ford.
Yes.
Motion
Alrighty. Move on to agenda item 6C. Another amendment to
Yes.
chapter 2110. All right.
Thank you, Blake. So this is commission consideration of resolution number 2020-30, a zoning text amendment to chapter 2110, summary of district regulations of the revised ordinances of the city of Watertown. So this is another ordinance amendment, as Chairman Dolly had explained or stated. And this goes back to a discussion we had last year, and because obviously I did not recall it from memory, I did listen back to hear where we had landed, and then so this is just memorializing it to get it in the books. So we had talked about properties adjacent to Lake Compesca or Lake Pelican. Right now, and specifically pertaining to docks and decks. Now, we might end up striking a portion about the docks, but we'll get into that. But basically, so at the lakes, the front yard is a 30-foot setback. So the front yard is the lake side. Typically, front yards are adjacent to the street, but at the lake, it is backwards. So right now, there's a 30-foot front yard setback from the ordinary high water mark of the lakes. And then where your structures, which typically decks are treated, they have the same setbacks as the primary structure. So they would have to comply with the 30-foot setback unless it was a patio where there wasn't any height to it, where it was just on the ground. Then that could be within the setback. But, so what this ordinance is proposing, and So it's stating decks, so this is where it states, decks shall observe the same setbacks as primary structures. See the table. Decks adjacent to Lake Kempeska and Lake Pelican may observe a 0-foot front yard setback in which decking floor shall not rise above the established grade at the 30-foot front yard setback boundary, only to allow for guardrails limited to necessary installation pursuant to international code. And that's very wordy, but it was actually kind of hard to try to put words together to hopefully accomplish what we want. So this more so if you think about properties at the lake where they slope down, and as long as that deck was not rising above the grade, the established grade where the house wouldn't be able to pass. So if the house is set back 30 feet, the deck would not be able to be taller within that setback than what it would be allowed to be if it was attached to the house. So when you're going, so if you are losing grade and you're sloping down, as long as you're not going, you can extend it from that elevation, but you can't, sorry, it's getting wordy. I'll put an example up here maybe.
Show and tell this time of night is always acceptable.
Yes, perfect. The mayor already put an illustration together. You want to explain it? I'll explain
it. Can you move it?
Here, at least.
There. All right, I drew this up for my own understanding of what we're talking about. On Lake Kempeska and Lake Pelican, the ordinary high water mark is the property boundary, and the setback is 30 feet from that. So if you can picture, the lake is over here, and here's the ordinary high water level of the lake. 30 feet back from that, it's probably not being shared on Teams.
Pete, is this being shared on Teams?
What's that? Can that be shared on Teams?
Let me try.
We're trying to figure out how to share that with everybody on Teams.
I'm gonna pull it
if
up
you could
on
hold
my
a sec.
phone, and then I'm gonna hold it above there.
Okay, so anyway, 30 feet back from the ordinary high water mark is the setback. And so where that setback lands when it intersects with the ground is the elevation at the ordinary high water, or at the setback line. So if you have a house with a deck sticking out from it beyond the setback, you could potentially block someone's view. And we don't want to block someone's view. Right now, you cannot build like that. That's why I said no. You're building into the setback. And so the proposed ordinance change would allow decks to be built at the lake into the setback if they're at that ordinary high water level or lower than. So in this second illustration, it's the same house position and the same deck elevation, but that has to stop at the setback line. That's where it ends. Then you figure out what the maximum height is, 30 feet back from the ordinary high water line, and that's the highest you can come up with a deck. And you're not going over the water there. The property boundary is right here.
Yeah. Okay, but anyways, the deck is right there. How many feet above the ground is the yes deck?
Is the deck?
Well, is that the deck? Okay, you got the step, and then you step down to
No,
a deck?
that's not a step. That's a deck. So you got to imagine.
Yeah, I'm saying on the yes one, you know, where you have the step and it's done. You can't go any farther. Then it looks like you step down to another deck?
Right, and that deck is allowable because the maximum height of the deck itself is no higher than the setback line where the elevation is 30 feet back. So you're not blocking someone's view. And that's the idea
And that
of it.
includes fences and everything, right?
This does
No.
not include fences. But that's a
So
conversation
someone-
for a different
So
day.
someone can build a fence all the way
Right
to the
now
high
they
water
can.
mark.
Right now they can.
My gosh.
And that's something
Unless
though
you're in my
that
subdivision.
that we'll look into that one next. But we just couldn't bring them together because they're not the same chapter.
Right now, you couldn't build a deck, like, just forget the houses there. You can't have a deck on, and people do. So many people do. I do. I mean, all my neighbors do. It's at the ground level. It's like a patio, and it's not blocking anybody's view. But you can imagine a situation where it might. And this came up at a staff meeting where we measured back, and the person wasn't actually requesting to go beyond the setback line, so it didn't need to come to the board. But we were concerned about the view blockage. And so if you are going to allow someone to build in that setback, it has to be down low so you're not blocking a view. That's the point.
I think this is a good ordinance, and I really think we should include an illustration like that in the ordinance if possible, just because it is a lot easier to see than read it on something like this. Like when you show the picture, I can see the difference between the no and the yes, but reading it, it's hard to visualize that. So thank you for providing that picture.
Well, and I had to draw it myself to understand what the words said. And you're right, if I have to draw it to understand it, how do we expect a citizen to understand it? We want it to be clear. And the whole point is to protect views while still allowing some use down by the lake. And normally, this only applies at the lake. You can't build in the setback otherwise. So only decks.
No, but I have seen some really nice decks out there where they are right there and stuff. And it looks really nice because they take the steps down and then it's a landing. It looks really nice.
Right, and technically that's against our ordinances right now.
Oh.
Yes, thank you for providing that. To try to figure out the language, I had to draw it on my whiteboard. And so this was very helpful because, as you can see, I was having a hard time describing it, so you saved me there. And then another part of this ordinance amendment, and we had thought about striking. So the other part, it was docks adjacent to Lake Kempesca or Lake Pelican have a 0-foot setback. The only reason that was included is because when a dock is resting on a permanent foundation, then it's considered a structure. So if it's within that setback too, even though they are temporary and they are removed, you would imagine, just cleaning that up so there was no question. Now, they also extend usually beyond the property boundary, which is kind of out of our jurisdiction. But at least then we're not, there would never be a question that, well, that is actually a structure. So it should not be within the setback.
Mr. Chairman, are you there? He just messaged him. We might have sound difficulties here.
Yeah,
there he is.
Can you hear us?
Okay, now we can.
Okay.
Blake?
Ms. Ford, I think you had a question.
I do. Can you hear me? I'm
Yes.
uncertain. Okay, thank you. If we could just go back to the decks for a moment. Is there anything in the ordinance that will prevent someone, if we're worried, if we're trying to preserve the sight lines for adjacent properties and neighbors, that will prevent someone from building something on top of that deck? For instance, an arbor, or put up a big sunshade on poles. So if you have a zero, if you're allowing those decks to be way down by the water's edge and someone builds an arbor or puts up a sunshade, then you are allowing, huge visual issues.
Yes, and that was we wanted to make sure to consider that and to not allow that. And so that's why we said only to allow for guardrails limited to necessary installation pursuant to international code. So only if a guardrail was necessary for safety purposes by the code is the only thing that would have any height difference.
So that means you can't put up a sun umbrella if you have 5 tables out there and they all have sun umbrellas on top.
I don't think this is regulating furniture items. It would just
Okay,
regulate structures.
Okay, that's good to know. I'm just trying to clarify so anybody who's listening to this
Yep.
will know what the do's and don'ts are and what's included and what's not included.
Yep,
So
so the
nothing attached except a railing, but non-permanent items would be okay.
Yes.
Is that essentially it?
Yes. No, so,
Okay.
yep, and no structurally attached, no pergolas, no
Okay.
double deckers, nothing.
Okay, I just wanted to just get that out in the open and get that clarified. Thank you.
Yeah, it's a good question.
To that point, I'm wondering if that language reads clearly. I was struggling interpreting it until this discussion just happened, where it says 30-foot front yard setback boundary only to allow for guardrails limited to the necessary installation pursuant to the international code. Should we expand on that only to allow for something to do with additional height obstruction for guardrails?
I think, and so when putting this language together, so it's hard because depending on like how high the deck is or whatever, the guardrail might be, or if it's commercial or residential, the guardrail might be required to be 4 feet or like 32 inches. So to leave that open to code, but then also I think that we're still protecting, because like somebody couldn't come in and say, I'm going to put a 7-foot guardrail up, because that would be the minimal. So we put limited to the necessary installation. So only what was necessary to meet code. And then as far as the height goes, it shall not rise above the established grade at the 30-foot, only to allow for the guardrails.
Should that say except to allow for?
Except, right.
But could you say unenclosed decks adjacent to Lake Compesca, blah, 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 30-foot front setback boundary, period, exception, only guardrails allowed, limited to pursuant to IBC code? Because that's what you're talking about, unenclosed decks, right?
Yeah, but that is what a deck
Well,
is.
What's an enclosed deck? Is an enclosed deck a deck with a guardrail
Enclosed deck
completely around it?
I've got walls and a roof.
Well,
Then that'd be a like structure.
yeah, that's a building.
That's my point. That's what you're talking about. I mean, if you're trying to keep things from going above the elevation of the deck,
We could limit the height too. I mean, we're saying IBC code, but
And we wanted to leave it open in case something would change.
changes, yeah.
I think personally, changing only to accept, it reads a lot more, it makes a lot more sense to me reading it that way.
And you should
Yeah,
use
I'm
the
with
word
that.
extend instead of rise.
Okay.
I've got a further question, and I guess kind of looking at the drawing that you had up there, Madam Mayor, where you do have a substantial decrease in elevation down to the lake. What if a person could have a deck that was had a pergola attached, but the top of the pergola was still below the elevation at the 30-foot mark?
No pergolas.
So we're saying nothing on the deck can extend past that mark.
Right.
Only decking floor.
Yeah, so if 30 feet back from your front yard setback is 15 feet in the air, and you're only building your deck back from the water, 15 feet back, right in the middle, it's very possible if you had a steep bank that you could have something higher than a rail. But the key point is that it does not extend above the established grade at the 30-foot front yard setback line.
Yeah, and if that's the intention, where we just don't want anything to extend past that 30-foot mark, I think we do need to change the wording a little bit. Because we do certainly have some of those situations on the lots that have extensive terracing requirements, where they certainly have more than just a handrail extending up, but they don't pass the
Yeah.
elevation at the 30-foot mark.
That's a good point. And that really the key is the elevation. You don't want it to be.
Right.
But we also don't want people putting structures. No structures are allowed.
Yeah.
All of those things are illegal right now. They built most likely without a permit, just thinking they
Right.
didn't need one. And we don't want to make everything legal necessarily. If it requires a building permit, the answer is most likely going to be no. Decks are different. And, I mean, if someone's going to claim that their elaborate gate and arch is part of their deck, I mean, I don't know. We don't want everybody to be illegal with the minor things that aren't intrusive.
I think this is good. I think I agree with the except as opposed to only. I think the putting in the drawing is going to will help explain everything, and you run with it until somebody tries to do something that you're not comfortable with, and then we change it then.
Yeah, that's a good approach.
Yep.
Did you open the public hearing yet? Mr.
I have
Chair?
not. I'll open that. Do you want to talk about the box at all? If there's anybody here to speak on behalf or against. Hearing none, I'll close the public hearing.
Yeah, I think I want to talk to Matt about it, see what Matt knows.
And Randy, could you speak to the striking of the dock language for right now? I think as staff, we could give that a little bit more research and talk more internally about the dock situation and how to incorporate that, if at all.
Yeah. Yeah, we would recommend at this time to just, when you make the motion, if you strike 2K and, 21-10012K and 21-1003-2F. And then we might end up presenting something, but it just might need a little more thought.
Mr. Chair, I'd like to make a motion to pass Resolution 2020-30, excluding 2K and 2F under 2103 and 2101, and to allow staff to put together a visual that explains what all the verbiage means and a little latitude on matching the verbiage to the intent of the drawing.
That illustration, do you think First District would help us out? Just kidding.
I'm sure somebody here knows how to do that.
There's a pretty good illustration already. I think we can just scan that in and use it.
That's
With a little advertising from the concrete company on there too.
There you
Or Photoshop it a little bit.
Yeah, that was really good.
Okay, we have a motion on the table. Do I have a second?
I'll second that.
Any additional discussion on this item? Take a roll call vote.
Kays,
Aye.
Spire,
Yes.
Hanson,
Yes.
Dolly,
Yes.
Oletsky,
Yes.
Brink,
Yes.
Ford.
Yes.
All right, thank you. Motion passes.
All right, we'll move on to item 6D on the agenda.
Okay, so this is the annexation. It's an annexation and zoning, so I will explain them all both together, but they will need separate action. So
Okay.
it's the annexation and zoning of the south 88 feet of the west 100 feet of Lot 4, Cook Cold Edition. So the first action will be commission approval of resolution number 2020-31, initiating annexation of a tract of land contiguous to the city of Watertown, South Dakota. And then 2 will be commission approval of resolution number 2020-32, establishing the zoning designation of R1 single-family residential district. So I'll pull up the map here. And so this currently, the Larry Maxwell and Emily Borkus are the owners of the legally described property in the county, which is this area here with the blue highlight. They currently...
You're not on Teams. At least I don't have you on mine.
Oh, okay. Okay. Is that better now?
Perfect.
Yep.
Okay, thank you. Sorry about that. So the Borkuses currently own this property where their home resides in the city limits, and then they own this back lot, which is in the county. What they're wanting to do is build a structure or a detached garage. It does not meet the county's minimum lot size requirement to get a building permit. So that is why they are proposing to annex and zone into the city, and then they would combine it. They would replat their lot and create one lot and be able to achieve a building permit. Simple as I thought that was going to be. Mark Meyer with Municipal Utilities had brought up the Sioux Rural Water, their consent decree between Watertown Municipal Utilities and Sioux Rural Water Systems. And we had, city staff had reviewed the consent decree and thought that by combining them into one lot, this lot is already served by utilities, and there is also a fee that goes along with it. So, and Mark can kind of explain that a little deeper, but they're concerned about the fee. Watertown Municipal Utilities is, when I talked to the applicant, we made them aware that they were in Sioux Rural Water's territory, and there was a possibility that they would have to pay a fee, which is $8,900. He still wanted to move forward with it. So, with that, I think it would be good if Mark...
Is that fee based on lot size or just flat fee?
It's... Yep.
I don't know. I'm reading the decree and it says at least 35 acres.
Yeah, I would disagree with that.
I mean, I think Jack Heeb said. I mean, I'm not going to get into the legal interpretation, but that's not my understanding.
No, I was gonna agree with you, Todd. I think that having heard what Jack's interpretation of what the consent decree's purpose was, I don't. And discussing this internally, it was our understanding and our position that this would not be a situation where the fee would be owed, and that we would invite them to challenge that interpretation.
And maybe I could also bring something to the table. I used to be the zoning officer for the county many moons ago, and there are several other garages built on lots that are in the county, as opposed to the lots in the city. And the reason for that was back in the day, those platted lots, they came in and got it. They came in to get a permit. The county issued a variance to their requirement, but the condition of the variance was that if and when the city ever asked to annex, that they would annex those properties. Well, since all of those things happened prior to joint jurisdiction, and now that we have joint jurisdiction, basically the county is saying we need to talk to the city first on this joint jurisdiction issue. And if the city does not want to annex, it would come back before the joint jurisdiction board, and then they could process it that way, and attach the condition to the variance. But I'm not exactly certain that makes the most sense.
Yeah, because in discussion with Luke Muller, county planner for Cottington County, he encouraged that the city annex them.
So I think for the sake of discussion, since Mark's here, I guess, Mark, do you want to just speak to the concern, or did Brandy summarize it well enough as far as utilities is concerned?
Mark Meyer.
Yeah, I'll open the public hearing. We'll actually open the public hearing for both of these to talk through. We'll take them as separate actions, but go ahead, Mark.
Mark Meyer, Watertown Utilities. The utilities attorney believes it's 0 to 35 acres, up to 35 acres. And his understanding is that if the land was already in Sioux Waters territory, we could continue to serve them. But it's already in the city limits, and we would be taking a piece of land that is in Sioux Waters territory, because that's the boundary line, is the south lot line. We would be fine with the annexation if the owner of the land is willing to pay the $8,900 fee to Sioux Water. It's not that we're against the annexation, it's just how would the utilities recoup the $8,900 fee because it's just going to be a shop, there's no water use back there or anything. That was our concern. So the utilities would be against it, the annexation of it, without the owner being willing to pay the $8,900.
What happened with all the mother garages and stuff, sheds that are behind them other homes? Were they just grandfathered in?
Those lots, those structures on those county lots have been given variances to have those things be located there up until the point in time that the city requests that they be annexed into the city. And the only reason they're being treated differently than Mr. Borkus was that they were, those requests were processed prior to joint jurisdictional zoning. Now, Mr. Borkus, if he chooses not to pay the fee, which in many ways to me seems more like an exaction than anything, and if we decide not to approve the annexation and zoning, we can theoretically, he could come back to the joint zoning board and ask to do it in the joint jurisdiction area, but a variance would have to be granted. And I think that's where Mr. Muller was saying it would be cleaner if we could just get him into the city because he's already in the city already.
Do we typically have the applicant pay the fee, or typically is the utility come? Yeah, we just do it. So
But it's passed on to the applicant.
This came in place a little less than 2 years ago. So this would be the first case that's like this. I did talk to Luke today, and I wouldn't want to put words in his, or say what I think he was telling me, is that the process is to bring it to the city first. And if the city denies it, he couldn't guarantee that the county would give a variance. But based on other situations, he believed that it would be favorable that the county would give a variance if the city didn't annex it, that the garage could still happen.
Which was news to me just before this meeting. But I don't really, though, from an annexing standpoint, that does not meet the city or the county building permit requirements. So when it's adjacent to city limits, it really should be annexed, and then it would meet our requirements. Now, as far as if Sioux Water would charge utilities, then you would turn and charge the applicant, which we made him aware of. And he
But you can't hold the fee to the annexation. That's an exaction. And we don't need to get into what an exaction is or is not. But I mean, he doesn't need the city water. He's already getting city water right now. And so by holding him hostage to paying a fee that he doesn't need for a service that he's already receiving in order to get an annexation and a zoning requirement, it's an exaction.
Is there any utilities to that back lot or intention to have utilities out to that back lot?
Not to my knowledge.
There's no existing utilities back there. I could see once a shop is built that he might want a fuel run for heat or, private electric service back there so he had power. But there's currently none that I'm aware of.
I just feel like it's odd practice to say, bring it to the city, have them deny it, and then but they're still in the joint jurisdiction zoning area and it's adjacent to city limits, so we should want them to annex.
Mark, do you know, is rural water close to that property?
I would say that my guesstimation is it would be, 1,000 feet or more. I don't believe that they have a main right there, but I can't be for sure on that. Right. Well, not only that, but I believe that the owner isn't probably wanting water in there, but this isn't based on whether they want water or not. It's based on when we take their territory. So even if they never want water back there, the way we understand this agreement is that once we take their territory by becoming city limits, that's what triggers the $8,900, not if they ever want water or not.
Because all of those lots are landlocked. There's no way you can get there without going through the property in the front off of Golf Course Road.
Well, I believe it's just a legal description that is described, so.
From the public, could I make a comment?
Yes, the public is open.
Okay, this is Dan Riefenberger. That area outlined in blue that they're trying to get zoned, I own all the land to the south of it and that west side of it. I guess I would like to know how he plans on getting access to it.
That property would become an extension under a replatting process where it would become an extension of his current lot, of the owner's current lot. And they would access it via the means of, through their property that they currently have access to off of Golf Course Road.
Okay, so it's only through theirs. They can't access from the side through my land.
No, it would just be within this public right-of-way that I'm outlining, if you can see that. But no, definitely not through your land.
Okay, because I get enough people driving through there into the back already, and I just didn't want another one coming from the side going in there all the time too. If he's going to come from the back where he has his house, fine, but not around to the side.
Yep.
Yep, that would certainly be a requirement that, he has to access from a public right of way or from his own property.
Mr. Chairman.
That's the only question.
I was just going to point out Attorney Roby's got his hand up on the virtual screen.
Mr. Roby?
There.
Thank you. I was just going to, make a couple comments. So it seems like there's two issues here, and this is the first time we've had to, the rubbers met the road on this agreement, and it seems that there's clearly a disagreement amongst legal interpretations. And so I think the first step would be to perhaps, for me and the utilities attorney, Mr. Foley, and the attorneys that were involved in this, Mr. Heeb out of Aberdeen, to converse on this, because the first question is whether or not this fee is owed. And if we don't believe the fee is owed, we should stand by that interpretation and move forward as if the fee is not owed, and let Sioux Rural Water challenge us on that interpretation. The second question is, if it is owed, then the question is, who pays these fees? And I think that that's a larger question that probably needs to be discussed, because this is a recent development. This was 2 or 3 years ago this consent agreement was entered into. And so obviously by entering into the city, properties, the city benefits, as well as utilities department of the city benefits by getting increased customers on properties that are actually building a structure on. And so I think that's the second point. But regardless of the outcome of those two discussions, here, if you recommend the annexation, we can have those discussions in the interim between this action and the council taking this up.
This is Mark Meyer again. I would just like to reiterate that as it stands right now, the utilities would be opposed to the annexation based on what the utilities attorney, his opinion is. How you vote is up to you guys, but the utilities would be opposed to it as, so just want to make sure we know that.
And to
Matt?
Matt's point, if I could further that discussion a little bit, to Matt's point, as staff, knowing the opposition from utilities, if the board were to pass this tonight, I like Matt's idea of getting with them before the final decision goes to the council for approval, and we could have, hopefully have these questions ironed out or be on the same page with the interpretation of that ruling. I think what Matt proposed seems ideal if the board were to approve this. That's how we would move forward as staff.
Or is the other option on the table that we table action on this until the legals can get together and come up with a recommendation to come back to us? And then, and maybe if we have to, we have a special meeting to reconsider this. So that Mr. Borkus doesn't have to wait.
I would second that.
I think that's an option.
I'll make that motion. I'm sorry, did you
I'll second that.
close the public hearing yet?
The public hearing is open if there's anybody else to speak before we proceed.
You know, there still would, and the motion was seconded, but there is still time to have those discussions and still keep it moving. Because ultimately, the $8,900 is going to come down on the applicant. And they're aware of that.
I don't think that that's settled yet, Randy. So just be cautious there.
Just
Okay.
from position from the Plans Commission, it seems like advancing now would be a potential risk associated with that, and not complete information to go forward on, and just be better to let the legal implications be addressed before we go forward as a commission to advance it.
I think I would disagree, and I would think we could go ahead and annex it because I think that's the right thing for the property, and we shouldn't look at the price tag that someone's going to have. It's a lot that's too small to be built upon in the county. So when they went to the county and asked, the Luke Mueller, the county zoning officer, for a building permit, he directed them to us for annexation. So I would think that, the annexation of that property is the right thing for it, and we'll let the attorneys decide who foots the bill, my thought.
Yeah, it does give me a little bit of pause as someone that has served on that joint jurisdiction board, where we're looking at something like this, where it's just an accessory structure and not a principal development. That it's not unreasonable that we wouldn't approve something like that through the joint jurisdiction. So I think it could go either way.
Mr. Chair, if you close the public hearing, I would like to make a motion.
I'll close the public hearing now.
I would make a motion to approve the resolutions for annexation on this property, subject to the getting a legal interpretation and presenting that to the city council.
We have a motion. Do we have a second for that? This is for the annexation?
Annexation, right? You have to have two separate actions?
Yes. Yep.
The annexation, I would move forward with the annexation and give staff the direction to sort out the legal issues.
Do we have a second?
I'll second. And just so I'm understanding this correctly, we want staff to sort it out, but either way, it would go to city council for approval if approved tonight, because if they, right, thank you.
I'm just, it's just direction. I mean, it's motion to approve, but we want staff to to get that figured out.
Yeah, I will
Correct.
second that.
Any additional discussion before we take a roll call on that? Okay, Brandy?
Kays,
Yep.
Spire,
No.
Hanson,
Yes.
Dolly,
Yes.
Oletsky,
Yes.
Brink,
Yes.
Ford.
No.
Motion passes.
And we'll have to take the zoning as a separate action.
I'd make a
Yep.
motion to rezone it as shown.
Motion by Brink,
I'll second that.
second by Oletsky. Any additional discussion? We'll take a roll call.
Kays,
Yes.
Spire,
Yes.
Hanson,
Yes.
Dolly,
Yes.
Oletsky,
Yes.
Brink,
Yes.
Ford.
Yes.
Motion passes.
All right, thank you. Next item on the agenda is open public comments. I imagine the room there is quiet. Is there anybody speak?
No.
Okay, we'll move on to item 8 for new business.
None.
Any from the board? On to item 9, old business.
None for me.
Anything from the board? Any reason for executive session?
No.
Then I'll take a motion to adjourn. Stein's
For
not
Mark
here.
Stein, I will make a motion to adjourn.
Okay, we got a motion
In memory of Mark.
I'll second that.
and a second. I'll take a roll call.
Kays,
Aye.
Spire,
Aye.
Hanson,
Yes.
Dolly,
Yes.
Oletsky.
Yep.
Brink. Ford.
Yes.
We're
Thank
adjourned.
you
Thank you,
all.
everybody. Thanks for the long night and the good effort.